Lordship, serial number 45, my lord. Senior some personal inconvenience, Lordship. Senior some in personal inconvenience. Next, please.
At the request of Law and Order, the appellant on the ground that the senior advocate wishes to conduct the appeal as personal inconvenience, comma, stand over to say 13th of June.
Please, your lordship.
Yes.
Posting memo, I'm requesting RP 498, same bench it is. Other matters are listed on 7-4. It can be clubbed along.
7.
Serial number 39, my lords. It may be adjourned, my lords. I received a copy of action today. I'm a petitioner in person in that PIL 39.
8th of yeah, what is it? You can do one. You can start it.
ಅಕಡೆ ನೋಡ್ತಿದ್ದಾರೆ. ಆ ಕಡೆ ನೋಡ್ತಿದ್ದಾರೆ.
8th of this month. Longer.
After vacation, my lord, I received a statement of objection. It's a contamination of drinking water.
My lord, in Tumkur, Chitradurga and Davangere, my lord, I have filed a detailed
I have to go through it and collect some data in that matter, my lords.
Twenty-second of April.
Yes.
Not after. 22nd April.
Grateful. It's okay.
Serial number 34.
Yes.
My lord, part in person. I am a fresh contempt. I am a complainant. So memo for posting for contempt petition. Fresh matter.
Not being posted.
Not posted.
When it is filed.
My lord, filed to April,
Alright.
February, my lord. February.
When do you want? 15th?
February 5. I filed February, my lord.
15th?
Okay, my lord.
15th.
Oh. Serial number 34, my lord.
Serial number?
34. And for respond number 1 to 3, we have queried the objections only yesterday, my lord. I have informed the petitioner. I'll file it and serve it on him on 2 weeks. But they have queried it only yesterday, the objection statement.
What is it about?
It is
what?
about environment clearance.
Environment clean. 34. 8th of 8th will do. Next week, 22nd of April.
If my lord, one matter for IA for vacating stay, my lord. The petition was filed under the Surface Act, my lord. There was a direction to pay 25 lakhs upon deposit of the 25 lakhs. Redelivery of position of rice mill has been directed, my lord. Sir, in the meantime, within 5 months, my lord, they have filed a writ appeal and obtained interim order, my lord. My client is ready and willing to deposit 25 lakhs and also one-time settlement, my lord. Sir, I request for IA for vacating stay, my lord. Sir.
23rd.
And next week, the action should be scheduled on 17/5 minutes. Further developments are there.
17th April.
8th, 9th or 10th minutes.
17th April.
No, 17th is the scheduled date for action minutes. Sale of assets.
9th.
Much worse.
Commercial appeal, my lord, fresh matter. Serial number 17, my lord, 117. Pertaining to PL matter.
117.
Permit him to withdraw the PL matter, my lord. The respondent assurance, given assurance to settle the dispute, my lord. So 117 pertaining to PL. Permit them to withdraw the petition.
My lord, this pertains to the establishment of a solid waste disposal unit, my lord, which they are opposing, saying that it is Goma land and the grazing land is insufficient.
No, they are not, till today
Withdrawing.
they are not.
For it to be permitted.
He is withdrawing, my lord.
Learned advocate for the petitioner, Mr. So-and-so, files memo dated 2/4/25, which contains the signature of all the petitioners as well as the signature of learned advocate. Your MK Shivaraj.
MK Shivaraj.
MK Shivaraj. Full stop. In the memo, it is stated that the petitioners want to withdraw the petition in view of the assurance given by the respondent authority to clear the garbage. Full stop. In view of the memo, without expressing anything in respect of the content of the memo as well as the merits of the case, the petition is dismissed as withdrawn.
Obliged.
Your Lordship, serial number 12, Your Lordship. 2 weeks time may be granted.
Serial number?
Time for the petition. Serial number 12, Your Lordship. 12.
Then it will go after vacation.
Yes.
Stand over to when? 12th June.
My lords, fresh matter, my lords, commercial appeal. The execution is coming on 5th, my lords, before the trial court.
To take time in execution. 5th it will not go.
Fresh matter, my lords.
Maybe, but we'll post it on 16th.
Attachment.
You can take time there. On the ground that the
Next week,
appeal
my
is-
lords. Some urgency, my lords.
You can seek time in the execution procedure. On the ground that the appeal is pending before the High Court.
Next week, any day.
Not possible. When the execution is closed.
5th, my lord, Saturday. coming.
Then what is the question? What is the difficult? Next week or on 16th?
This week can tell the trial court that it's listed on.
16th.
Next week, my lords. Any date, my lords.
16th we are giving, 16th
Next
April.
week.
Kindly, serial number 32, my lord. Appeal for the petitioner's counsel. Matter pertains to direction issued to the Tahsildar, personally remain present and also file an affidavit confirming the fact that the documents are available. You all noted it. They have appeared because they have not served copy on us regarding the affidavit so far. That's why we moved the matter requesting whether he's filing the affidavit today or not. Otherwise, it may be taken up on Monday if you are not filing. The government has to file.
So what do you want?
And I have some inconvenience now. I received a call.
Some other day?
Taken on Monday. If they are filing, my lord, my colleague will be present.
Affidavit be filed, my lords. Tahsildar is present with the records, my lords. Affidavit be filed today, my lords.
So when shall we keep?
Next week.
Monday.
Monday?
Please,
8th.
please.
8th.
Let him serve copy.
Lordship, serial number 119. I'm withdrawing the appeal, Lordship. I'm filing a memo.
Right.
Yeah.
I appear for respondent in this case.
Contempt petition number 495/24, learned advocate. It is connected with appeal.
No,
No, that matter is not connected.
not connected.
119,
119 is
sorry.
not connected.
Read appeal number 1193/24. Learned advocate of the appellant tenders memo on record dated 2/4/25. Seeking permission to withdraw the appeal. The permission is granted, the appeal is dismissed as withdrawn. It is clarified that this court has not gone into the merits of the case and the issues involved in the appeal in view of the withdrawal. Full stop. All the interlocutory applications which are pending stands disposed of in view of the withdrawal of the appeal. Shall stand disposed.
Serial number 114, my lord. 114, my lord, they have completed the order of the single judge of this honorable court. The contempt petition may be disposed of in this matter. They have completed the order.
Learned advocate Mr. Ramesh K.R. stated. Which was
My senior name is Ramesh K.R., my lord. My name is Sunil Kane.
So and so stated, so and so appearing for learned Ramesh K.R. for the complaint stated that order under contempt is complied with. Who appears? Your learned additional government advocate, Srimati Pramodini Kishan, confirms the victim of compliance. In the aforesaid view, nothing survives in the contempt petition. It is disposed of as not surviving.
Obliged.
Lord, serial number 46. The appellant, 46, my lords. The appellant has died on 15th of February. I am filing a memo reporting the death of the appellant. The appeal stands awaited, my lords.
46, learned advocate Mr. Sanjay Krishna
Yes, my lords.
files memo disclosing the victim of death of,
Appellant, my lords. Sole appellant.
so it will not survive. We want to bring the air.
My lords, we have no instructions from the legal heirs to continue this appeal. We have no instructions from the legal heirs to
instructions.
continue this appeal.
Also, if further the memo is taken record. So it can be disposed. Learned advocates paragraph stated. While disclosing the aforesaid fact of death of the appellant, that he has no instructions
Yes, my lords.
to prosecute the appeal.
Yes, my lords.
Nor has any instructions from the legal heirs. Full stop. In that view, the appeal is disposed of as not surviving. Wherever, however, liberty is reserved for the appellant. To bring on record the legal representatives of the appellant, this is appellant, if the legal representatives so want, and the cause of action for them survives.
Yes. Grateful.
As on today, it is abated, my lord. They can seek for setting aside the
It is
abatement.
what says, full stop, the such application.
For setting aside
in Such
abatement.
eventuality, application may be, application is permitted to be filed within 6 weeks for setting aside of abatement and implement of the heirs.
Grateful.
Disposed of.
Serial number 42, my lord.
42.
The matter is posted for my lord, for the response of the respondent. This is the third time it is posted for the.
Lord,
same.
notice had been issued on the last date, my lord. I need 4 weeks' time to
Lord,
file. my reply.
For this reason, I insisted for an interim order on the last occasion, Lord, and in the very first instance. They have seized 3 trucks carrying full earth, that is clay. This is a seasonal business that ends in the month of June. They have permission only till June. And despite pending this petition, they have seized.
Next
The vehicle, my lord, the vehicles have been released, penalty has been paid. My lord, there's nothing in this petition.
File something, then we can dispose.
They have to come up with some stand, Lord, as to why they have seized the vehicle and imposed penalty. They cannot make loose submissions before the court.
My lord, let him not, my lord, make loose submissions, my lord. He's making loose submissions.
Lord, day before yesterday, on Friday, they have seized 3 vehicles again.
Where is the loose submission?
I
Lord,
don't
Lord,
know why I'm attacked, my lord.
because Lord,
Asking them
He
to file-
doesn't know how to speak English. And he's
No, I
before
have to
my
learn.
lord, and he says
That
loose submissions.
Anyway, that's a part.
My lord, I've just received the objection this morning. My lord may grant me some time. My
21st.
lord may see it was posted on 19th. Then my lord was pleased to issue notice on 4th of March.
16th of April will do.
No, my lord may have it on 22nd or 24th.
Lord,
21st.
my submission is.
21st.
Lord,
June is far away.
Lord, my submission is on Friday, again, they have seized 3 vehicles.
My lord,
Imposed
I'll bring to
penalty,
my lord's notice.
imposed penalty.
My lord,
Since there are,
When they are saying that penalty is already paid.
no,
Well,
so far,
paid.
in this case also penalty is
Then
paid.
we'll.
No, may I make a submission.
Yes. if
On
there is-
Friday, again, they have intercepted the vehicle and
he'll have to file a
demanded.
petition.
we may take up when it is called out instead of so that it.
My
can-
lord, no, my lord, I've just received the instructions this morning.
No, my submission is, Lord,
Time.
every now and then, they intercept the vehicle and impose penalty. Lord, knowing very well that there were 3 days holiday. We have to pay penalty under compulsion. This is for extraneous reasons, Lord, that particular officer is intercepting the
My
vehicle.
lord, there's no.
We have all the documents.
File affidavit a little bit early.
Let them file an affidavit
My lord,
to justifying their action, Lord, at least.
There is no interim period.
no.
Lord?
There is no interim period.
No, Lord, we have, There is-
My copy doesn't.
there
give any-
is interim prayer, Lord. There is,
Anyway, if you want to take up the matter today, we can take up when it reaches.
My lord, I
please,
need
Lord, I'll wait.
some-
Let it be called out, yes. Yes.
Any mention through easy, sir? Content matter, seal number 1, Mr. Nayak VS.
But complainant, while working as a driver, met with an accident. As a result of that, my lord, he was incapacitated to drive the KSRC vehicle. He was given a light duty as per the regulations. However, my lord, the P fixation was not properly done.
Notice returnable on 17th June.
But
Seal number 2. Yes,
Please, Vilads, I appear for Srimati Pramoda Devi Vadiyar in the Chamundeshwari temple matter, which is a writ petition that is pending before this honorable court. The matter that's listed before my lords is a contempt petition, which has been filed for blatant violation of interim orders of this court of the 26th of July, 2024, wherein there is a specific stay ordered with respect to the Chamundeshwari Kshetra Development Authority Act by this honorable court, saying that the act shall not be brought into force. But between the 26th of July 2024 right until September 2024, the state government continued to take action with the complete knowledge that there was an embargo on their ability to enforce the act. In fact, they moved a clarification application on the 13th of August, asking for this particular order to be vacated or modified. And in the meantime, they continued to implement it from the 27th of July 2024, that is a day after the order was passed. I would request my lords to give us an opportunity to ventilate the submission before the honorable court, because the chairman of the authority, which happens to be the honorable top executive member of the state government of Karnataka, has himself initiated steps in violation of the order of this honorable court. Most importantly, religious affairs of the temple were interfered with, and we have no idea what is the status of steps taken by the state government during that particular period. Subsequently, in September 2024, this honorable court passed another final order, another interim order. We have no idea whether this order is also being complied with, because under this order, Ms. Vadiyar is expected to be party and privy to every meeting that is undertaken by the authority. Informal meetings are being carried out without notice being issued to us, which is in violation of the order. So we want to place those aspects as well. But before my lords today are at least 5 different examples, or at least 3 different examples of violation of the order of 26th of July 2024 in the form of articles and letters. The instructing counsel before my lords is also carrying fresh material showing further violations during that particular period. My lords is aware of the law laid down by the Supreme Court that as long as an order is in force, even if it is modified later, any step that is taken by a party which is bound by that order during the substances of that particular order is in violation of that particular order. And there is judgment to that effect. There are several judgments to this particular effect. We only request my lords to kindly take cognizance of this, because we need some clarity on what is the extent of violation and how much of a bearing does it have on the rights of Ms. Vadiyar, as well as the interest of the deity and the religious affairs of the temple, the jewelry of the temple, because the nature of the act is such that the state government is empowered to take over the jewelry of the temple completely, replace the existing customs and traditions of the temple in violation of the provisions of the Karnataka HRC legislation as well. So this is a super legislation with a super executive authority presiding over the temple and its affairs. Therefore, Milans, kindly consider issuing notice in this matter. We'll happily present ourselves in person before my lords to explain this in further detail, but there's a clear violation. Can I just show a few letters and a few documents from the contempt petition so that my lord sees what is the nature of the violation here? I'd request my lords to kindly take a look at the first order of 26th of July 2024, which is the first interim order that is passed, which is Annexure A to the contempt petition, Milords. This is Milords Annexure A. This is after page number 16. This is the first order of 26th of July 2024.
So this interim order is subsisting today?
That interim order was modified subsequently, and I'll show that order as well. Can I just show that order, my lords? This was modified on the 14th of October, sorry, 5th of September 2024. Can I just show that order as well?
What is the modification?
The modification, my lords, is, there are about 5 aspects which are covered with the consent of the state government. I'll just submit this for my lord's consumption. Para number 5 of the order reads as under. Let me just read this for the court's benefit. Mr. Devadas, learned Additional Advocate General, appearing for the respondent, fairly concedes, that is the state government, that pending the disposal of this writ petition, neither the movable nor the immovable properties belonging to the temple will be disposed of. He also submits that the prevailing customs and the traditions of the temple shall not be modified or interfered with during the pendency of the petition. Then para number 6 is a direction from the court.
Mr.
Please.
Counsel, it is vacated, not modified.
Because my lords is correct. In the sense, it is vacated and it's replaced, my lords.
Vacation is falls apart.
My lords is correct. I stand corrected. The only submission is during the please, my lords, my apologies.
You are not misleading the court.
No, my lords, absolutely not. Which is why I'm showing the order, my lords. My
When you are saying that it is modified.
No, my lords, my apologies. That's not what I meant.
Vacated is never modified.
My lords, my lords is correct. I didn't mean to mislead the
But
order.
we are not inclined to entertain only on the ground that it is interim order.
My lords, can I just show the law on the point just for a moment? Just 5 minutes.
Yes.
Just 30 seconds, and I will not take my last time beyond that.
Yes.
Please, I'll just, this citation is All Bengal Excise Licenses Association versus Raghavendra Singh and others. This is a judgment of the Supreme Court of 2007. I'll just give the citation, my lords. Does the instructing counsel have the copy? My lords, the copy is actually being handed over to my lords of the judgment for the bench itself. 2007, 11 SCC, page 374. This is the judgment. In this, the specific issue was the violation of an interim order during the subsistence of that interim order, and this was taken up after the modification and vacation of that order. So the court said that if there was an order in place and the respondent was bound by it with the knowledge that it was bound by it, then there is absolutely no explanation or justification for the brazen violation of it during its existence. Can I just show portions of that to my lord's consumption? Does my lords have the judgment? Please see the facts which are captured on the first page of the judgment, which is page number 374, internal page 374. Please see, challenging the policy decisions for issuance of excess. My lords has it. Can I read that?
Yes.
Please, minutes. Challenging the policy decisions for issuance. I'm reading the head note on page number 1 of the judgment. The policy decisions for issuance of excise licenses for opening of new foreign liquor off shops and country spirit shops in West Bengal as violative of the provisions of the Bengal Excise Act and the rules framed thereunder. The Appellant Association filed a writ petition against the Respondent Principal Secretary Government of the West Bengal. An association of licensees was also impeded. The High Court passed an interim order permitting the respondents to process the matter, but not to finalize the same and issue the license without the leave of the court. During the continuance of the interim order, the respondents got an advertisement published in the newspapers for holding lottery for final selection of excise shops on 20th of March, 21st of March, and 22nd of March 2005. Please note, my lords, the interim order was passed on 4th of January 2005. The High Court passed an interim order on 4th of January 2005, permitting the respondents to process the applications, but restrained them from making any final selection. Then please see, it says it was by different orders extended from time to time. That is, the interim order of 4th of January 2005 was extended from time to time and was continuing at the time of the hearing. Xerox copies of the said orders were communicated to the respondents by the appellant's advocate. In our case, it stood communicated to them through letters and emails as well, and to process as well. The appellant herein then filed a contempt petition before the High Court, alleging that the respondents had deliberately and willfully violated the said interims of the High Court. At the instance of the state government, the High Court vacated the interim order passed in the writ petition. However, it granted liberty to take steps to issue licenses. In the contempt proceedings, the contemptors pleaded that although there was a violation of the order dated 4th of January 2005, but the said violation was not willful, as the contemptors had wrongly understood the implications of the orders passed. Please note, the interim order of 4th of January 2005 that was passed by the court or by the High Court stood vacated. The contempt petitions were being entertained after the vacation of the interim order with respect to violation of the interim orders. which existed at that point. And the contempt was filed on 4th of September 2024 in our case. That is before the vacation of the order by the 5th of September order. My contempt petition was filed on 4th of September. And I'm alleging violation right from 27th of July 2024 until September 2024. So the issue primarily before my lords is to share the conduct of this particular party and to also understand the extent of violation undertaken, because this is an ongoing dispute before this honorable court. The simple issue before my lords is this: whether the Chamundeshwari temple belongs to the Vadayar family or not is already pending in a writ appeal before this honorable court, before a division bench. During the pendency of the writ appeal, the state government passes this Chamundeshwari Kshetra Development Authority Act, taking over the temple completely in violation of Karnataka Legislative Assembly rules, saying you cannot pass a legislation or even move a resolution or issue a speech on a matter that is sub judice. Therefore, a sub judice matter has been taken over through a legislation. And when the order was passed that the act shall not be given effect to, because there's an outstanding issue that is pending, that order is passed on the 26th of July 2024. From the 27th of July 2024, systematic destruction and violation of the order begins and goes on until September 2024. And in September 2024, the court vacates that order and replaces it with an undertaking and a direction, which is captured, which I read out to my lord's consumption. The point is, traditions have changed, properties have been taken over, jewelry has been confiscated, priests have been changed, private temple has effectively been converted into state property, which the state has no business being in, which is why, my lords, at the very least, they need to file an affidavit to explain what were the steps that they undertook from the 26th of July 2024 until the 5th of September 2024, so that the court has a clear knowledge of the extent of violation with their willful knowledge of the existence of the order. They themselves move a clarification application on the 13th of August, admitting to the existence of the order. I did not come to this court after the vacation of that order. I came to this court on the 4th of September. This is in the interest of preserving the temple property, my lords, and nothing beyond. We are only asking for some notice to be issued so that we have some clarity as to the extent of violation. Only then we'll be able to take some stock of what is to be done next with respect to the final interim order that was passed on 5th of September. Can I just show paragraphs 33 and 34 of this judgment of the Supreme Court, which specifically addresses my lord's concern? Kindly see page number 399 of this judgment, paragraphs 33 and 34, where the court is taking cognizance of the violation of an interim order after its vacation. Which is why I'm showing this judgment. Kindly see page number 399, paragraph 33 and 34. Can I read this for the court's benefit just for 2 minutes? Can I?
Notice returnable on.
I'm so grateful, so deeply obliged.
Our learned senior advocate so and so. Video conference assisted by learned advocate so and so is present in the court. Notice returnable on. These sightings and judgment. Almost near to the facts for the time being. It can be.
I'm so grateful, so deeply obliged.
Subject to what are the other sides?
Absolutely, I'm so grateful, and I'll make myself physically available on the next date of hearing for my lords.
Returnable on. It will go on June.
Could it be perhaps in July? Kindly consider, because in Delhi, June happens to be a vacation. Please consider.
July.
Please, if possible, July. Yes, my lords.
All right. 7th July.
7th. I'm so grateful. I couldn't have asked for more indulgence, my lords. Grateful for the patience.
I make one submission. My lord may take, the order of the learned single judge dated 22/8/2024. My lord, we have already filed a memo saying, my lord, that this act has already been given effect to 22/8/2024.
Please see the order of 30th of August, where the court extends the interim order after the 22nd of August. I hope that is also brought to the court's attention. These interim orders were continued to be extended until September, and it's on record. Even after they brought this to the court's attention, the court specifically extends the order on the 30th of August. Kindly take a look at that as well.
You are saying that you purged the contempt.
No, they say
no. My lord, the act has already been given effect to.
So you purged the contempt.
Implemented. Yes, it's implemented before the filing of the petition itself.
Very well, we'll see on.
Grateful, so deeply obliged. 7th of July minutes?
Yes.
Grateful.
it is
The
serial-
notice
if it
returnable.
is serial number 3, man, if it is serial number 3, accept notice for the,
Notice returnable on
accept notice, man,
17 June. Learned advocate Mr. Chandrachud accepts notice on behalf of
both the accused. One
of the
submission,
respondents.
one submission may make, my lord. The description of both the accused have been wrongly named. The designation is correct, name has been shown wrongly. So that will come in way of me filing the wakalat.
The, at the outset, learned advocate for the petitioner complainant submits that he may be permitted to correct the
We will correct it, my lords, in
name
the
of
next
the
date of hearing.
respondent number 1 and 2.
This has been given by our client,
Permission is
so we'll just have a
granted, the-
cross check and
Get the
we'll just
correct
check,
name for
yeah,
the
we'll
counsel.
change it. Kindly post it on 12/6, my lords, because there is a connected matter with the same matter. my lords.
Notice has been issued and I have taken notice already and the compliance.
That is for
certificate also
217,
taken.
my lords.
In
For
the
this, we
meantime,
have it.
correct the title. Permission is granted, the correct name shall be. The title
12/6,
shall be amended with by correcting the name of the respondents. Well, Notice shall go after correction. Notice returnable on 12th of June. The notice shall be issued with registry after and subject to the correction of the name of the respondents.
So maybe notice may be dispensed with. I will undertake to.
That you already learned advocate which once accepts the notice when issued. Notice
Please.
returnable on 18th June.
Direction is at page number 81.
No time
Writ
limit.
appeal has been filed.
4 months from the date of receipt of the.
Notice returnable on 9th of June.
Lords, it may be tagged along with the writ appeal, my lords. Objections have been
That will-
cleared.
Notice returnable
Writ
to
appeal
be
number 475 of
Date on
2020,
16/6.
470
5 of 2024, my lords.
on 16/6.
Yes.
Obliged.
16th June.
For 6.
Petitioner is a MD student in radiation oncology, lordship. She had scored 49.25 marks and she preferred a writ petition asking for the rounding of marks to 50, lordship. Honorable Court has directed the university to correct the marks card and give a fresh marks card and declare her as passed, lordship. In spite of request and the time given by the RGHS lordship, the respondents have not complied with it. And they are having a examination, NEET examination, which she has written with the knowledge of the court lordship. And she has to declare, the university has to declare either to pass or fail by the end of this month. So we are asking for there are several writ petitions of this annexure C, page 29, lordship. By then we have to submit either we are pass or not, lordship. RGHS is
15th April. To serve them directly.
please, lord.
Service by hand summons is permitted.
Please, lord.
I appear for the petitioner.
For 7.
This is that contempt matter, my lord, where there's aggravated contempt. And your lordship recollect the AG appeared and said they will
Appeal
resolve.
for the respondent, KDB.
Yes. What is the progress?
Alas, we had, Lordship, can you take the memo which we are filing? You didn't give till now. Your Lordship, may kindly turn to page 6 for a moment, my lords.
Can I request page 6, last paragraph, my lords? Finally, the chief executive officer and executive members spoke informing that the meeting in view of the order of the Honorable High Court and interest of KDB, if the cornerstone that the complainant identifies 300 acres of alternative land in other industrial area being acquired by the board and the request for allotment, steps will be taken by the board to allot the land, fixing the rate for the regulation. So we are ready to give them 300 acres, my lord, which we asked them to identify the land.
I have to identify the land that they have. And
Which
then
we
I
are-
have to pay them the rate as on today, my lord, which when they had to actually allot the land to me. Which is completely contrary to the order. This is not what the discussion, apparently I was, at least my instructions were completely different. To say, my lord, that we should go identify the land which KIDB has somewhere else and ask for allotment. This is like saying, my lord, nothing at all. This is practically, this is classic case of aggravation of contempt. I have to identify the land which they have.
My lord, with great respect, my lord, they have, my instructions are, we have shown them the land, which is just adjacent to.
How can they admit, how
My
can
lord,
they identify?
with great respect, my lord, I'll file it.
They
on
would not
affidavit.
knowing the availability of land.
With great respect, my lord.
We are actually trying to assist them, my lord, and trying to find a solution.
No,
When they are in contempt of the orders of the court.
Then go together both and identify.
My lord,
No difficulty, well, if they,
with great, one submission, with great respect, my lord, we have shown them the land. They are very well aware which is the land which you have shown them.
Then why is this statement here then?
I'm quite shocked that my learned friend has been instructed to say that we have not shown them the land. We have shown them 1,000 acres of land. No, let me complete this. I've shown them 1,000 acres of land, which is right adjacent to this land. And we have requested them to identify 300 acres of the 1,000 acres. They are fully aware, my lord. I'll state it on affidavit if you want. And I don't
file
know.
it, let them say so. Because if they have identified the land, I don't know why the minutes say that I have to find the land and give it to them. If this is, my learned friend can't have it both ways. My learned friend says they've identified the land, shown the land on one hand. In the minutes, it is written that I have to identify the land and give it to them. At least, my lord, let them be consistent about what they are saying.
My lord, their advocate was present, my lord, whom we have shown them the land.
You can help them out, your officers, in identifying land to their
My lord,
satisfaction.
we can do it right now, my lord. There's no problem. If they come today, right now, we can identify. We'll give the sketch also, my lord. There's no problem as to that at all.
But let them file an affidavit showing which lands are available. We'll go there, no difficulty.
And
I actually
affidavit for what?
To say where the lands are.
Let them come right now. We'll show them the lands, my lord.
It's not showing, not saying lands are here or there. Let them say what lands are available and show it to us. Which they have to do, my lord. Ultimately, it is like I have gone through all steps of the litigation right up to the Supreme Court. And I'm brought right back to where I am.
I agree, my lord. The resolution could have been more aptly worded. But my instructions are, my lord, we have shown them 1,000 out of 1,000 acres, which is very close to this land, to identify 300 acres of land. And which is not more than
Total acres, sir.
distance from this land.
Same, 2-3 kilometers.
Just 2 kilometers away from this land, my lord. We have shown them.
Then say that in your minutes at least.
My lord, my learned friends instructing counsel was there, very much present. They are fully aware of it, my lord. In spite of this.
And I don't know what land is being offered to.
Oh, he says he's not seen the land.
In the meeting, it was discussed, my lord.
These minutes are only given now. We've not even seen it before. Let them tell us where the land is and file an affidavit before your lordships. We'll see it. I can't say anything more because I don't want to contradict the learned AG in what is happening. But the minutes show something completely different than what he is at least saying. If learned AG is saying land is there, we've identified. Minutes say you identify it. How can it be both ways?
Well, we'll modify the meeting's resolution and we'll point out to your lordship, my lord. Here is the case, my lord. Anyway, I don't want to go into the merits of the matter, my lord. We'll identify and we'll point out, my lord. If they come today, instead of filing it, let them come for inspection and take it, my lords.
All right, this is acquired land.
This should be acquired land from what they are saying, if it is KITB land. Therefore, they have all the details. Let them say, tell us this is the extent which is available and where it is. We'll go and see it.
Your Lordships are right, my lords. It's an acquired land, my lords, which is being
Then
allotted.
just point out, that's all.
Along with the sketch, I'll point out, my lords.
Acquired land is always identifiable land.
Identify.
Yes, absolutely, my lord. There's no problem on that, my lords. Absolutely no problem on that, my lords.
Lordship may have it next week. Let them then show us where it is. We'll
You
go
can
and see it.
approach by addressing a communication that please identify the land which you are referring to.
I'll do it. We'll do it today itself, my lords. I bow down to your
Let them give
lordship.
it,
I'll do
Lord.
right
Let
now,
them
my
send
lord.
a communication. No difficulty.
I'll do it right today itself, my lords.
Learned Advocate General appearing through video conferencing, tenders through Learned Advocate Mr. So and so memo. Dated 29/3/25. Please take on record. It entirely produces copy of the proceedings of the meeting of the committee to record thus in its final conclusion. Outcome, paragraph 6 and 7. Also, learned senior advocate Mr. Dhyan Chinnappa for the petitioner stated that he has serious reservations about what is stated in the memo and the decision of the committee. However, reserving his admissions in relation thereto, he submitted that if the authorities are to identify land and to show to the petitioner, the petitioner will consider the
Alternate land.
further consider the subject matter further.
Yes.
At the request of learned respondents, stand over to
Lords may have it next week, my lord. Otherwise, it'll never.
Please, my
20.
Can it be little earlier, my lord?
Little earlier.
14.
15.
15.
Please, my lords.
Great.
My lord, this is in public interest litigation. The petitioners are the localites of the Nagarbai village and the Canara Bank. The PDA approved the layout of Canara Bank Colony Employees Cooperative Housing Society for formation of layout, my lord. In that layout, certain lands were left out as a civic amenity sites, my lord. In that fifth respondent, who is a private respondent, has encroached illegally and is constructing the house, my lord. That is annexure B is the plan, my lord. Annexure B is the plan.
My lord, I appear for respondent 2 to 4, my lord. This is coming up for the first time, my lord. I seek some shorter adjournment, my lord, to seek instructions.
So which is the plot number?
My lord, this is, it's a Nagarbavi main road, my lord. Opposite to site number 181. Site number opposite to 181.
Your prayer says site number 47.
47, it's a created document. Based on the created document, they are processing to
So
construct.
if you read directing the official dispatch number 1 to dispatch number 4 to prohibit the respondents and remove the illegal encroachment, occupation, possession, and construction of the house on the civic community site.
Yes, my lord.
Number 47. So where
It's
is
a
the
created document, my lord. They,
Where is that
in fact, there is a site in this layout which is formed by the society, my lord.
where is the civic community site number 47 in the map.
They have, based on the document, created document, they have encroached.
We do not know. Map में कहाँ है? Where is that site?
Map, my lord, opposite to 181, it's a Nagarpavi main road, my lord. In that, opposite to 181 site, it's a Nagarpavi main road. And there they have constructed the
Which page?
well,
Which page?
page 37, my lord, annexure B.
37.
And I've already produced the photograph as well.
No, we want from certified map. The site which is identified as civic enemy site and which bears numbers 47. Otherwise, your case can't go further.
My lord, annexure C is the
Unless
document.
you show that site number 47 is civic community site from some authentic document, your case cannot go further.
My lord, let them file the reply statement to such an extent.
When there is no case, where the case is filing?
My lord, I've produced the photograph, my lord.
Photograph we don't. You have to produce an authenticated document, either in nature of map or some other document, which will reflect that site number 47 is reserved for civic community site.
My lord, in annexure C, there is a mention of Bangalore, Bruhat Bangalore Mahanagara Palike. There is a clear mention. In that site only, they are constructing the shops, man, residential house. Annexure C, my lord. Bangalore, Bruhat Bangalore Mahanagara Palike. It's a display, it's a board, my lord, it's a board. They have removed that and they are constructing the house, my lord. And I have produced the photograph as well. And I have got recently, today, just 1 hour back, I've received the photograph. This is the status of the.
Or learned document GT Kumar for the petitioner. The present petition. The petitioners. And in numbers. Comma is styled as public interest petition, in which the prayer is made for issuance of direction against the respondent authorities to remove the illegal encroachment, occupation and possession, as well as construction of house, building on the civic amenity site. Civic amenity will see civic amenity site, bearing number 47 at Nagara Bhavi NGR, Nagara Bhavi Main Road, Ward number 127, Mudala Palya, Bangalore. Also, the case of the petitioner, inter-alia, is that the Bangalore Development Authority paragraph approved the layout plan for the Kendra Bank colony employees covering certain server numbers. Also, the layout plan was approved in 2004. Also, it is the case that in 2023, the petitioner came to knowledge about the illegal encroachment, possession and construction of house in the civic community site bearing number 47. It was submitted that respondent 5, who is a private respondent, has been putting on construction on the said civic community site. So therefore, the efforts prayer is made. Full stop. Nowhere from the record, from a learned advocate for the petitioner was able to show that plot number 47 in the layout is designated as or earmarked as the civic community site. On the contrary, the map produced at page 37A indicates otherwise. Full stop. And the basic premise of the case of the petitioner is not substantiated, and there is nothing to show that number 47 is a civic community site. The entire edifice of the petition falls down. Full stop. The court is, the facts do not convince the court. The petition is misconceived and meritless. It is summarily dismissed.
Number 9, Mr. Mahendra Kumar Mitra, party in person.
My lords, I have filed this petition as the selling limit of reservation has been exceeded in our state, my lord. That is, as per Indira Sawhney case, the reservation, the percentage of reservation must be 50%, my lord. Whereas in our state, it has been exceeded to 56%, my lord. And the respondent number 4, my lord, in the year 2021-22, my lord, they have enacted an act, my lord. That is the scheduled caste and scheduled tribes reservation of seats in educational institutions and appointments or posts in the services under the act, and that act was implemented by 2023, my lord. So it clearly violates the Indira Sawhney case judgment, my lord.
Third learned party in person. Petitioner party in person. The case of the petitioner in this public interest petition is that the Karnataka scheduled castes and scheduled tribes into bracket reservation of seats in educational institutions and of appointments or posts in the services under the state bracket or Act 2002 into bracket Karnataka Act number 1 of 2023, which is published in the Gazette dated 12/1/23, has the effect by virtue of its provisions to provide the reservation to the reserved category persons, public candidates, excess of 50%. Full stop. A tabular form is given into page 12 of the appeal, seeking to substantiate the contents, the submission that the percentage of reservation calculated on the basis of the different category reservations exceeds 50% to go to the extent of 56%. Post of various contentions and advanced, seeking prayer to set aside the notification and to declare the aforesaid act to be liable to set aside, to be set aside as unconstitutional. It is the case of the petitioner, or it is the case of petitioner that in providing the reservation beyond 50% from the law laid down by the Supreme Court in various judgments on the received has been violated. Full stop. Rule returnable on 13th August. Reply shall be filed.
Number 10. So Mahendra Kumar.
My lords. Next D, my lord, page number 131, my lord. The government of Karnataka issued a circular, my lord, that the term Dalit should not be used as synonymous to the scheduled caste and scheduled tribes, my lord. Despite of this order, my lord, even my cousin brother, late CM Narayan advocate, filed a representation before the deputy commissioner, that is respondent number 9, my lord, to implement this order, circular, my lord. The respondent number 9.
Already a circular, you want to implement it. There is circular. What is wrong in it?
But this has been not been implemented, my lord.
We do not give the instances.
The official term for us is the scheduled caste, my lord. Even it has been decided, defined in the constitution as per article 366 clause 24, my lord. Even the print and electronic media, my lord, and there is an Madhya Pradesh High Court order also.
So when anything to show that it is not implemented? Anything to show or substantiate that the circular is not implemented, except your say in the petition?
Well, grant me some time, my lord, I will prove.
The petitioner is a party in person. The prayer in this petition paragraph, styled as public interest petition, is to direct the respondent 5. That's the Principal Secretary, Department of Social Welfare, State of Karnataka, to implement circular dated 28/5/2022, issued by the Social Welfare Department. It is also read to direct the other respondent authorities to implement the said circular. The circular in question, paragraph. Copy of the circular in question, figures on record into bracket at annexure D, page 131. It inter alia provides that it inter alia contains instructions that in all official transactions, matters, dealings, certificates, the term scheduled caste and scheduled tribes, the words Harijan, inert comma, and Girijan should not be used. Full stop. Circular is based on the decision of the High Court of Madhya Pradesh, Gwalior bench, which in order dated 15/1/2008, passed in writ petition number 20420 of 2017 in Dr. Manohar Lal Mahor, MHR versus Union of India, observed and directed as an court this page 131. In the aforesaid, in light of the above, from the circular dated 20th/5/2020, issued by the government of Karnataka, requires all departments to follow the following instruction. Then quote from page 132. Full stop. When the party in person, when the petitioner makes a grievance that the aforesaid circular is not implemented by the authorities, there is nothing to show or substantiate the case of the petitioner. Full stop. A mere statement in the petition would not be suffice to convince the court that the circular is not implemented. On the contrary, the presumption is that it is government's own circular which will be and is being implemented by the authorities. Full stop. It goes without saying that the circular or its avowed object of social justice and respecting the caste description will be observed as provided for in the circular. The present petition is accordingly not entertained.
Please, my lord. Seal number 11. Please, my lord. My lord, this is a petition where the validity of a statute was challenged. They have filed a counter. I am ready, my lords. The lords,
My lord, if
I have a
this
short
could be-
note.
What is challenge?
My lord, page number 55,
Religious structures.
religious structures. Perhaps. There are only 4 or 5 main points. I have also a note.
My lord, could I make one submission? My lord, learned advocate general, my lord, has some inconvenience. My lord can have it after vacation, immediately after vacation.
These pleadings are over, then we'll.
Yes, yes. Readings are complete.
We'll grant time, not that, but.
Please. Or if your lordship permits, my lords, I can make my submissions today. As your lordship pleases.
My lord, immediately on the reopening day, my lord.
That much time will not grant because we are.
My lord, in the connected matters, my lord, I'll seek instructions because, my lord, they are all old matters. I haven't received 2017. My lord,
And
as
time
on
to-
date, what has happened, I wouldn't know.
15th or 16th we can. 15th or 16th.
Tentatively, my lord.
16th.
Tentatively, my lord.
Then. We don't
I-
know we don't know tentatively what we'll do.
I'm sorry then. Okay, very well, my
So
lord.
16th of.
Obliged.
Your reply is fine.
Reply is fine.
Replies filed.
Therefore,
But with regard to the connected petitions, my lord, I don't know what the status as on date because they are of the year 2017 and 19.
it is a division bench matter connected petition.
Please, my lords, all the connected matters, my lords, is the main one is the suo motu petition registered by this honorable court pursuant to directions of the honorable Supreme Court.
Earlier one.
Please, my lords, earlier.
It will come before this bench.
It'll come.
PIL. It's also PIL.
It's also a PIL.
Then we'll direct you.
Suo motu petition, my lord.
11.4 is the suo motu petition.
It is already there.
It's already there. They're all listed
Then
together.
All right, 16th of.
Obliged.
Great.
April. Want to see next one? This was which 11.
Thank you.
This was
Oh, it's done.
now.
Citations you don't want to give me?
12 is over.
You give it to me, let me be.
So 13 follow.
Number 13. State appeal.
Lord,
Date
there
is
is a
there.
delay, my lord.
Delay of
167 days delay, my lord.
Learned additional government service.
Okay, wait a minute.
That shall be noticed in the delay condition application returnable on 19th of June.
My lord, the respondent number 1 is on caveat, my lord. We'll get the copy. Respondent number 1 is on caveat.
So rest are to be served.
Only sole respondent.
Only sole rest.
On the institution is
down.
the institution is respondent number 2.
Count down the delay.
Yes.
Delay.
My lord, respondent number 2 is the institution. I have to take out notice on the institution.
That is what we are saying.
I
Yes,
find my objection to the application. sir.
Learned advocate so and so accepts notice on behalf of respondent 1.
This colleague will not.
Serial number 40, item number 44 of
After recess will take.
I'm for.
After recess.
after 17, item number 17, my lord, identical matter notice has been issued to the respondents.
So notice returnable on 17.
Please,
Which date?
uh,
After
after vacation.
19th of June.
Obliged.
My lord, serial number 40.
Serial number 15, my lord.
15, yes.
Can you have the
Notice,
next some income?
notice written on 13th of June.
44, item number 44, my lord.
I appear for the appellant, my lord, in 44.
Yes, it will reach.
It will reach.
You
Yes,
will-
I'll wait.
Necessarily,
I'll wait.
Please.
naturally, yes.
With your lordships, kindly, your lordships have reserved on matter KPCL selection matter.
With your lordship's kind permission, my lord. With your lordship's kind permission, serial number 120, my lord, it could be taken up next week, my lord. Today, we have some difficulty.
I'm appearing for the respondent. Yesterday it was listed at my request, your lordship have listed. 7th at 2:30 minutes. If they have any personal inquiries and not come in the way.
And it has to be posted for final hearing, my lord. It was in the final hearing list only. Now it has come back to preliminary hearing stage.
It has to be heard, my lordship, more difficulty because 2:30 minutes
No,
at our, at
no,
my
no.
request, will only minutes, the matters. kept
We were
at
not
2:30.
notified, my lord. We were not aware of it.
Colleague was there yesterday, minutes, when the mentioning was made, colleague was there. But 7th at 2:30 minutes.
It could be taken on 15th, my lord,
16.
or 11th.
11th, let it be on 11th minutes.
Yes, my lord.
Sorry, but
It could be
Can it-
15th.
Let it be on 15th.
Yes.
In the hearing list, because they already it is posted for final hearing.
Lords, it's
Now
anyway
it is in
taken
the
up at
preliminary
2:30
hearing.
minutes. I really do not
no,
understand
no.
what difference it makes to
No,
them.
no, after
There is
preliminary
a-
hearing
there is a-
only matter was posted for final hearing.
There is already an order.
Now it is in the preliminary hearing list.
Please.
Yes.
Fifteenth at 2:30 minutes, your lordships. No, my lords, nobody is objecting, my lords, for your lordships fixing a date at 15th at 2:30 minutes. Absolutely, your lordships business, my lords. So,
Yes,
15th at 2:30 minutes. Lords, it's, yes. Let it be at 2:30 minutes on 15th.
109.
Lords, merely because, my lords, it's not. Lords, I know, I understand, my lords, this kind of petty complaints should not be entertained also. Lords, may make
109.
this, lords, may make this request. Lords, kindly permit me to say
109.
this, my lords.
109. Memo is already placed on record for withdrawal. It may be ordered accordingly. 109. A memo is placed on record. It may be ordered accordingly. It's already placed on record. It is in.
Lords, my sincere apologies, my lords. May just, lords, there is some urgency in the matter. At my instance, my lords, the matter is taken up. The appellant, my lords, wants to drag on the matter, and if he wants to make an objection, my lords, if your lords is
With your lordships,
15th, my lords. 15th at 2:30 minutes, may request.
with your
Please.
lordships, kindly, my lords. The lordships have reserved on KPCL selection matter for.
Your Lordship, 111, I appear for the complaint. 111, Your Lordship. I appear for the complainant, Your Lordship. No, Your Lordship.
With your lordships, kindly, your lordships have reserved on KPCL selection matter pertaining to negative marking. Your lordships have directed us to file synopsis, my lord. Today I'm filing synopsis. KPCL negative marking, my lords. Your lordships have reserved it for orders. Your lordships have directed us to file synopsis.
Great. Serial number 52, my lord. Shorter accommodation may be given. Serial number 52, my lord.
Yes, ma'am. Matter may not reach it, ma'am. Sure. May not reach it.
Pardon?
Yes. Matter may not reach it, ma'am. It's 52.
We don't know, it might reach, let's take up. Like. You are nobody to say that matter will reach or not reach. Yes, come on.
My lord, I am the
Argue.
advocate for the complainant in serial number 2, my lord.
We are not entertaining anything about the reaching of the matter. Yes,
I tender my apology, ma'am.
proceed. Proceed with the matter.
I tender my apology.
No
My
apology.
lord,
We are taking up the matter. Proceed.
My lord,
I sincerely tender my apology.
We don't want apology. We want you to proceed with the matter.
my lord, I am the advocate for the complainant in serial number 2,
Please
my lord.
proceed. Please argue.
Yes, ma'am.
Please argue. What is it about? It is PIL?
Yes, ma'am.
Yes, argue. It has reached. Counsel is not ready to argue the matter. Dismiss for want of prosecution.
No, no, ma'am. Ready.
So when will you argue?
No, no.
When will you argue?
So it's
When will you argue? Today, tomorrow, day after tomorrow?
day after,
Yes.
day after tomorrow.
Day after tomorrow. Sing it on. This will be after. Yes.
Okay.
Next.
My lord, I am the advocate for the complainant in serial number 2, my lord. I was just directed now to appear by VC and represent my lord.
In this matter, number 2 and 3 were not party in the original proceedings.
Yes, my lord.
So in any case, we are not inclined to issue notice to, for the present at least, because it doesn't appear to be necessary against number 2. Who is 3? Therefore, you are called. 3 in particular, 3. Number 3 notice will not go. You delete number 3. Number 3 is already represented by the secretary. That to alleged secretary. What kind of raise you are raising? Alleged secretary. So are you deleting number 3 or not?
My lord, I would just like to make one submission in this regard, my lord. The thing is, my lord, when I had filed the writ petition 19807 of 2024, there were no actions that was taken by the state government, my lord. But however, by the time
We
I
are
had
asking you are inclined to delete number 3 or not. We are not ready to issue notice, at least at present, against number 3.
I need to take specific instructions
No
from the
instructions.
complainant.
Full stop. Full stop. Heard learned senior advocate Mr. J. Sai Deepak, pre-video conferencing, assisted by learned advocate Mr. S. Smita Datta, who is present in the court. Full stop. At the outset, it is to be observed that respondent 3, Sri Siddharamaiah, described as LS chairman of Sri Chamundeswari Kshetra Development Authority, Chamundi Hills, Mysore, is not a necessary party in view that the development authority is already represented as per the description contained for respondent 2. In that view, notice shall be issued to respondents except respondent 3, returnable on 7/7/25.
Much obliged, man.
When shall we take up that matter? Supreme Court direction.
108.
3:30 or right now?
Whatever is convenient to your lordship, I'm ready.
Shall we proceed?
No, it is not yet completed. I mean,
Then
otherwise they'll start.
No, I'm not completed.
That's not
Court is asking now or when?
now or after half
We
an hour?
will finish it today itself because it was parted unless the court is inconvenienced. No,
We
otherwise.
are convenient, only thing that's.
I won't take too long, Lord. I'll finish very quickly. But just to recap on what was said, I had given your lordships a list of dates. It is undisputed, my lord, that this is a
Yes.
the Jodi Inam land,
Hmm.
and one KP Ramaya was the Jodidar.
Hmm.
Property was purchased not by one Kaveri Reddy.
Hmm.
It is said, Lord, that he had mortgaged about 160 acres of land in favor of one Muni Bhairappa. That is what they say.
You gave that, huh?
I'd given your lordship a short list of dates.
Yes.
1948, notice that mortgage from Kaveri Reddy, which was in favor of one Muni Bhairappa for 160 acres of land. And no permission was obtained, not post facto, which was the requirement of the law. Otherwise, the mortgage becomes invalid straight away. 10/3/1953, it is claimed that one Doddaya filed a suit for recovery of money. On 17/5/1956, Kaveri Reddy sold the entire extent of 500 acres in favor of Kempaya, who, my lord, was the person who was in occupation and possession of the property of 500 acres of land. 56. Then, Lord, on 1/2/1959, the notification issued by the government.
Appellant is Kempai.
Kempaya, legal representatives of Kempaya.
Yes.
After the purchase by Kempaya of the 500 acres of land, on 1/2/1959 came the notification whereby, my lord, the entire property stood vested with the state in terms of the Karnataka Personal and Miscellaneous Inams Abolition Act, with which, my lord, the land vested with the government free of all encumbrances and became the property of the government, subject, of course, to one condition, that if persons who are entitled make an application within the time prescribed, their claims with respect to the property will have to be considered. After which, in my humble submission, there could not have been any execution proceedings with respect to that property, because in 1964, they say they initiated an execution proceeding, and in 1966, a sale certificate is issued by the court in favor of Doddaya. And in 68, Doddaya sold the property in favor of Kemparaju. These two, in my humble submission, could never have occurred after 1959.
So sale certificate as well as the sale could not have taken.
Could not have taken place. Both are invalid in law. And my lord was pleased to notice section 3 the other day, which said all attachments, injunctions or any kind or any other orders passed, all of them with respect to a particular property goes away because the property vests with the government free of encumbrances.
Yes.
Then, Lord, in 1973, there was an amendment to the Act by virtue of which the last date for filing any application was extended up to 31/12/1979. And then Lord recollects, there is no application filed by Kemparaju at any point in time
This 10(3) is what?
I beg your pardon, my lord?
Section 10(3)(a) is what? For getting the land.
Yes, my lord. 10 is the consideration of applications.
No.
Yes, the consideration of the applications and the time limit within which you can make the application.
Application for getting the land back.
For getting the land. Then Lordships recollect 1810-2000. The next date, he makes an application to be impleaded. Kemparaju makes an application to be impleaded. And your Lordships were pleased to see the order of the KP, the DC, or the special DC at that time, the Karnataka Appellate Tribunal and the High Court, which said that does not mean he has a right. And that was rejected. Then, Lord, in 2017, the Land Tribunal rejected his application, primarily on the ground that he had not even made an application as required under the Act, and therefore the question of him making a claim does not arise. These, my lord, are the facts. Now, my lord, may kindly see the order of the learned single judge. As to how, my lord, the learned single judge considered his claim and then answered it. The order, my lord, starts at page number 38. And the consideration, my lord, starts at page number 98.
This is arising out of which petition?
This
2709?
Yes. 27409. That, my lord, will find
27409.
27409. At page number 58. Kemparaju, my lord, is the party. The contentions, my lord, is at page 87. If my lord, I'll just show your lordships one. The contentions urged by my learned friend before the learned single judge at para 11. CS Prasanna Kumar, learned counsel appearing for petitioners. My lord has got that. In writ petition 27409, argued that the respondent land tribunal failed to consider that the petitioner Kemparaju got right over the land in question, as per the sale certificate issued by the Municipal Court, Bangalore, in execution petition number 151 of 64 in favor of one Doddaya, who had filed suit for recovery of money against Kaveri Reddy in original suit number 93 of 53 and got land in question attached on 31st August 1953. The said suit was decreed on 11 December 1954. He further contended that the petitioner Kemparaju purchased a scheduled property from Doddaya, and in this regard, he refers to the proceedings in original suit number 93 of 1953 and execution petition number 151 of 64. And contended that the entire extent of land of 494.25 acres is a Jodi Inam belonging to KP Ramaya, who had sold in favor of Kaveri Reddy, from whom Doddaya purchased an extent of 160 acres in pursuance of a court auction as stated above. He further refers to mortgage deeds said to have been made by Kaveri Reddy dated 29 November 1948 in favor of Muni Bhairappa and execution of sale deed dated 20th June 1956 in favor of Kempaiah, contended that the respondent land tribunal ought to have considered that the share of Kaveri Reddy was to an extent of 160 acres only, and same was the subject matter in OS number 93 of 1953, which was sold by Doddaya in favor of Kemparaju, and said land in question was attached before judgment. Same culminated in a court auction by virtue of decree being passed, which ended in issuing a sale certificate in favor of Doddaya being a successful bidder. He also refers to several rounds of litigation before the land tribunal and this court, and argued that the records before the DC were destroyed on account of fire. File was reconstructed as per circular dated 29 September 1981. He further contended application filed by Kemparaju seeking re-grant was not traced on account of destroying of the entire records, as well as misplacement of records by the respondent land tribunal, and the aspect has not been properly assessed by the tribunal while passing the impugned order, arrived at a conclusion that Kemparaju had not filed application seeking re-grant is totally unacceptable.
Case was that application
For the first time,
first time
ever in the last 60 years, my lord, of this litigation going on.
before single judge only.
Only before the single judge for the first time, because this is clear, my lord, from the fact that he made an application to implead himself in the year 2000. If he had made an application to implead, he could never have to be impleaded. He would have simply said, I have made an application under form number so and so. You must now consider my request. He does not say that. He simply says, implead me. Kemparaju has not filed application seeking is totally unacceptable, untenable finding recorded by tribunal. He further has submitted. Respondent land tribunal has not made any effort to trace the application made by Kemparaju seeking re-grant, despite the direction issued by the court in the writ petition, which is per se violation of the order passed by this court. Next, it is contended by Prasanna Kumar Learned Counsel. Mortgage deed dated 29 November 1948, executed by Kaveri Reddy to Munivarappa was much before the coming into force of Mysore Alienated Villages Protection of Tenants Act 1950. Therefore, Section 6 has no application to the transaction. But Lord, this act says any mortgage which is prior to 1950 should get post facto approval, otherwise it's invalid. The requirement of the 1950 Act was any mortgage created before the Act come into force has to be given post facto approval. If you don't get post facto approval, then the mortgage is invalid. Therefore, that also, my lord, in my humble submission, is erroneous, a contention. Therefore, I contend observation made in the impugned order, mortgage is without permission as mandated under Section 6 of the Mysore Alienated Villages Protection of Tenants and Miscellaneous Provisions Act 1950 is an erroneous finding which requires to be set aside. He further contended that vesting of lands under Inam's Abolition Act is not to extinguish the rights of the parties, nor intention of the legislature that the land to be appropriated by the government, and on the other hand, the land is to be re-granted in favor of a person who is cultivating the land in question through proper acquisition. In this connection, he contended that after vesting of the land, state government has to identify the persons who are entitled for re-grant of such lands, in which right is vested with the persons who are entitled for re-grant, and therefore he contended these principles cannot be brushed aside on a technical ground by the respondent land tribunal in the impugned order. Sri So-and-so Learned Counsel invited the attention of the court to Section 10 of the Mysore Inam's Abolition Act and submitted that the said provision does not confer wide powers to respond land tribunal. Powers are restricted to go into the application relating to the details of the subject land, inter-alia, earlier ramdar, nature of his rights over the land in question, and in that aspect, the application seeking re-grant is to be made in favor of such applicant. In this backdrop, the counsel submitted that the power of AC to confer occupancy rights and to declare the applicant as Khadim tenant is wider in nature, and therefore finding recorded is required to be set aside. That's the contention, Lord, of my learned friend. Then, Lord, consideration of this aspect, I'm only referring to Mr. Kemparaju's claim, is at para 32, page 117, 117, running page 117. It is also to be noted that on careful examination of the entire finding recorded by the land tribunal, finding recorded by the tribunal rejecting the claim made by T. Kemparaju is contrary to law. At this juncture, it is to be noticed that Kaveri Reddy had purchased trees from Doddaya and failed to pay the debt, resulting in filing of original suit number 93 wherein the suit is one for recovery of a sum of rupees 700. It is also to be made known that the scheduled land belonging to Kaveri Reddy was attached in the above suit. Suit came to be decreed on 11th December 1954. Now the conclusion is, therefore, I am of the considered opinion, Section 6 of the Mysore Personal and Miscellaneous Inams Abolition Act is not applicable to the land which had been attached in original suit number 93, since the attachment is made on account of non-payment of debt by Kaveri Reddy. In my humble submission, completely contrary to Section 3. The said attachment cannot be construed as sale, mortgage, lease, other assignment or alienation of the land in question.
This attachment was.
Attachment, not the claim was made in the suit that was filed by Doddaya.
Attachment was done on which date?
The attachment date, my lord.
Was it prior to that notification?
Prior to the notification.
31/3/53, my lord, the date of attachment.
So that appears to be the crux of the matter.
That is the reason the learned single judge says, because there is an attachment, therefore the act does not apply. Now,
because the attachment was prior to notification.
Yes. Now, if the attachment was prior to the notification and act does not apply, then I ask myself, why will he make an application under the act?
The suit is of which year? 1950?
1953. The claim is there is an order of attachment. Let us assume, my lord, there is an order of attachment of 1953 itself. And the suit is decreed in the year 1954. Now, my lord, please see Section 3 of the Inams Abolition Act. What happens to attachments?
Then let us.
Three 1H. This is after the date of vesting. H. F, my lord, I'm sorry. F. 31F.
No such.
No such inam shall be liable to attachment or sale in execution of any decree or other process of any court, and any attachment existing on the date of vesting or any order for attachment passed before such date in respect of such inam shall, subject to the provisions of Section 73 of the Transfer Property Act, cease to be in force. Therefore, the attachment which is prior to that date ceases to be in force on 1/1/1959. If I may draw a parallel, my lord, if land is acquired under the Land Acquisition Act and the property is under attachment by a court, it does not mean that the property will not vest with the government, because property vests with the government by operation of law. And the second property vests with the government under the operation of law or by operation of law. The consequences, everything that is there and existing on that day goes away and it becomes vested with the government free of encumbrances. And because of the provisions of the Inams Abolition Act permitting a transfer upon an application being made to a person who may be entitled either as a tenant or an inamdar, that order can be passed. Learned single judge, therefore, my lord, saying that because there was an order of attachment, it is outside the act itself. In my humble submission, Lord, did not notice section 3F, 31F. Please see, Lord, the order that is continued at the bottom. The said attachment, it says, at the bottom of page 117, last line, said attachment cannot be construed as sale, mortgage, lease, other assignment or alienation of the land in question in respect to the above provision of the Act. Taking into consideration that the share of Kaveri Reddy in the scheduled land to an extent of 160 acres in terms of finding above, in view of recitals in the mortgage deed and also the partition deed, the petitioner T. Kemparaju in writ petition number so-and-so is entitled for relief to an extent of share of Kaveri Reddy in the scheduled land. At this juncture, it is pertinent to mention here that the sale certificate dated 19th August 66, that is after 59, was issued in favor of Doddaya, and as the share of Kaveri Reddy was brought up for sale at public auction in execution petition number 151 of 64, and in the said court auction, Doddaya had purchased the extent of 160 acres, which was sold subsequently in favor of Kemparaju in terms of registered sale deed dated 21st March 1968. In that view of the matter, I am of the view that as Kemparaju derived his title to the property through registered sale deed dated 21st March 1968 and the issuance of sale certificate dated 19th August 1966 in favor of Doddaya, the sale deed dated 25th June 1956 executed by Kaveri Reddy in favor of Kempaya is void to an extent of 160 acres. Is void to an extent of 160 acres, which is the subject matter and original suit number 93 or 53, in view of the law declared by Honorable Supreme Court in the case of Tika, para 13 of the judgment reads as under. We need not multiply decisions as the legal position is clear, and it may be stated as follows. Where a property has been legally attached by a court, the possession of the same passes from the owner to the court or its agent. In such situation, the owner of the said property cannot take the law into his own hands, but can file a claim petition to enforce his rights. If he resorts to force to get back the property, he acts unlawfully, and by taking the property from the legal possession of the court or its agent, he is causing wrongful loss to the court. As long as the attachment is subsisting, he is not entitled to the possession of the property, and by taking that property by unlawful means, he is causing wrongful gain to himself. We are therefore of the view appellants in unlawfully taking away the cattle from the possession of the decree holder, who is only a bailee of the Sapurdar, has caused wrongful loss to him, and therefore they are guilty of any offence under section 424 IPC. Lord, if I may humbly say this, possession and ownership are two completely different things. Attachment does not result in vesting of ownership. It is only that possession of the property is vested in court and nothing more. Attachment only results in vesting of possession of a particular property in the court and not of ownership. It is well settled principle in law. Sorry.
But the vesting,
Vesting is in 1959.
that is a different vesting.
No, that vesting is very different. Lord. That vesting clears it of everything. This, they say.
Vesting by way of attachment is a different concept of vesting.
Beg your pardon, Lord?
Vesting under attachment.
No, in attachment, there's no vesting of the property.
It is only a vesting of possession.
It's only vesting of possession at best. That is, if possession has actually been.
It's not a vesting.
It's not a vesting in terms of law. Therefore, my Lord, using this authority, which in my respectful submission did not take into consideration the consequence of vesting under the Inams Abolition Act and the consequence of the property becoming the property of the state, to then say, on the one hand, the learned single judge, my Lord, holds that the act itself does not apply to this land. That's the first finding. Then, Lord, it goes on to say that you must grant it under this act. CPC. It is well, my lord, I may read 33. Again, there's a reference to. It is well settled principle in law that a private alienation of property after attachment to the competent court is void as against the claims enforceable under the attachment.
This Kemparaju comes into picture in what way?
In the year 2000, Kemparaju comes in 1966 when he purchases that property.
66. It is the sales certificate.
68, no, sorry, 68.
68.
21/3/1968. It is a Dodaya purchases in a court's auction. Kemparaju purchases from Dodaya.
But that sale could not have taken place.
Could never have taken place.
So you are asserting what right?
No,
I mean, Kemparaju.
Kemparaju is saying that he got that right on the basis of the sale deed. And he tries to justify it by saying, there was a court attachment with respect to this property prior to the date of.
You are not the heirs of the Kemparaju.
I'm Kempaiah, my lord.
That
I'm Kempaiah. I'm sorry, that names are. Kemparaju, my lord, is the meddlesome interloper. So far as we are concerned, at least.
So how Kempaiah comes into picture?
Kempaiah, my lord, purchases this entire extent of 500 acres of land.
When?
That plot is 1956, first page of the note. 17/5/1956. I purchased the entire extent of 500 acres in favor of Kempaiah.
And you are saying now that that transaction will sustain.
This transaction, my lord, is in accordance with the permission granted by the Deputy Commissioner.
No, that will continue to remain valid to vest title in you.
Yes, my lord. That vests title in me. Not the inherent contradiction, if I may say so, with great respect to learned single judge, is on the one breath to say that the act does not apply. But then to proceed to grant the same land under the act. Your lordship saw the first finding which learned single judge made, my lord, at para 32, last line.
What is the effect of this 59 notification?
That land vested with this government.
No, on your right.
Mine also is gone.
Gone.
All rights, not including my right, goes to the state. Thereafter, the state, through the land tribunal, determines the question as to who had the rights
Under that.
prior to 1959, and then says if you have the right, you are entitled to it. Therefore, my lord, a creation of a right after that, it is like saying, my lord, after the acquisition notification, there will be sales of the property. Can they come and then say, I have had a sale of property now give me that right in the property? That's exactly what's happening here. This, my lord, is the crux of the issue. Now, the learned single judge proceeds on the footing that because there was an attachment, and we don't admit it, my lord, but I'm proceeding on the basis of what is said here, that there was an attachment. Because there was an attachment, therefore it stands outside the act. Respectfully, it can't stand outside the act because of section 3(1)(f), which makes it clear that an attachment which exists dissolves itself on the day of the notification, that is in 1959. And if it dissolves, then there's nothing left for anyone to claim under a court or ask the court to execute the decree and sell the property and then purchase the property. There was a 66 sale in favor of Dodaya, and the 68 sale was of property which did not vest with anybody. And therefore, my lord, Kemparaju can never come before the court.
So what is the as such eligibility to get the land back?
You must be an owner in possession of the property or a tenant.
Where it is provided?
That is in section 456 of the act.
That is.
My lord, may kindly see 4, my lord. Four is every Kadim tenant of the Inamdar shall with effect on and from the date of vesting be entitled to be registered as an occupant in respect of all lands which immediately before the date of vesting were properly included in his holding. That is Kadim. Then 5, my lord, is permanent tenants. Subject to provision so and so, every permanent tenant shall with effect on and from the date of vesting be entitled to be registered as an occupant. 5. Then your lordship may kindly see 6. 6 is, my lord, a similar provision for quasi-permanent tenants.
They are defined, all this.
Yes, no, they're all defined. They're all defined terms.
You belong to which category?
We are the Inamdar. Your lordship recollect, Inamdar or their successors in
No, no.
interest.
Khadim tenants or what?
No. We fall not under 9. All of us will fall under 9 because we are owners of the property.
Oh, owners of the property. Section 9.
9. Every Inamdar, your lordship will see, every Inamdar shall, with effect on and from the date of vesting, be entitled to be registered as an occupant. There were no tenants.
No tenants.
No tenants.
No, but why we are asking to him that whether he has got any right a priori by
Yes.
virtue of his becoming the first purchaser.
Purchaser.
Is there any such provision that you get a right in priori or?
Well, yeah. No,
No,
whoever is the owner,
Under section 10,
whoever is the owner.
order of priority.
Yes, no.
What is that order?
No, my lord. Order of priority, tenants are in order of priority. And if there are no tenants, then alone will the Inamdar come.
Oh.
That your lordship will find in section 9(1)(2). Every Inamdar shall with effect on and from the date of vesting be entitled to be registered as an occupant of all land other than these lands. But 2, lands in respect to which any person is entitled to be registered under section 4, 5, 6, 7 and 8. That's first priority to tenants. If tenants are not there, then Inamdar can say there are no tenants. And this property at that time was something called a Becharak village, which I don't think there was much to be cultivated at that time. Therefore, this village became available for allotment to the Inamdars. Question was, who is the Inamdar? And if he is the Inamdar, how much of the property is he entitled to? There was me who was claiming 500 acres of land. Then there was another set of 3 people who claimed about 320 or 40 acres of land. Then suddenly, when we were all fighting for many, many decades, one person called Kemparaju comes in the year 2000 and says, I am entitled to 160 acres of land. So that is, my lord, the entire actually history of this litigation. From 1959 onwards, this litigation has been going on. Kemparaju's appearance is for the first time in the year 2000. And then, my lord, may see 10. The tribunal shall examine the nature and history of all lands in respect to which a Kadim tenant, a permanent tenant, a quasi-permanent tenant, the holder of a minor inam, or an Inamdar claims to be registered as occupant under sections 4, 5, 6, 7, and 9, or the holder of minor inam claims to be registered as a holder under section 8, as the case may be, and decide in respect to which lands the claim should be allowed. This is the decision that the tribunal takes. A tenant found to be in possession of any land on the first day of July 1948 shall be presumed to be a quasi-permanent tenant as defined in clause 14 of subsection 1 of section 2, unless the Inamdar proves that such tenant is not a quasi-permanent tenant as defined in clause 14 of subsection 1 of section 2. Provided that in case of a tenant in minor inam, such presumption shall be raised. Then 3A, my lord, which is important. No person shall be entitled to be registered as an occupant under section 4, 5, 6, 7, and 9 unless the claimant makes an application to the tribunal. Every such application shall be made in respect of inams which are vested in the state before the commencement of the Karnataka Inams Abolition Act 1973, within 6 years from the date of commencement of said Amendment Act. So, my lord, 3A1 applies to this case. Whoever has had to make an application should have made an application within 6 years, which is, my lord, on or before 31/12/1979. If you have not made it, then the consequence, my lord, is in B, 3B, where no application is made within the period specified in clause A. The right of any person to be registered as an occupant shall stand extinguished, and the land shall vest in the state absolutely. Such land shall be disposed of in accordance with the rules relating to grant of lands. Therefore, my lord, in my humble submission, learned single judge erred in making two findings. One, in making a finding that the existence of any attachment results in the act not becoming applicable, or that the land going outside the act. If, my lord, the land goes outside the act, as held, my lord, by the single judge at para 32, now, my lord, please see para 33 now. As to how, my lord, in my respectful submission, the finding itself is an answer to the argument. Para 33, my lords have it. It is well settled principle in law that a private alienation of property after attachment by the competent court is void as against the claims enforceable under the attachment, which is, my lord, section 64 of the Civil Procedure Code. My lord, a person who has an attachment can say the transfer is invalid, but no one else can say it. And you can say it so long as the attachment is valid. If the attachment goes, then the question of saying that the transfer is invalid, in my humble submission, does not arise. The person who holds an attachment, that is Doddaya, can turn around and say, possibly if there was an attachment, can say that the transfer in favor of Kempaya was invalid, as against me, not as against the rest of the world. Because it is only against the claims enforceable under the attachment, because not then, if the property has to be sold, then it will be sold as if it had to be sold by an order of the court. That is in a normal situation, not in a situation where an enactment has come into effect which has taken away the attachments which were created in favor of a particular party.
So the question might be that whether operation of law will prevail or decree of the court will prevail.
I think that answer, my lord, is, I would humbly submit an answer which necessarily will have to be seen from the act itself, because the act deals with that attachment and says if there is an order of attachment, then that order of attachment stands dissolved by operation of law. Now, unless someone challenges that provision and says that it is invalid, Lord, I would humbly submit a consequence of vesting of property with the government Therefore, my lord, my respectful submission is an attachment which has stood dissolved by virtue of operation of law, which is almost similar, my lord, to an acquisition under the Land Acquisition Act, Even if there's an order of attachment, that order of attachment also goes. No one can come and tell your lordships later when land is acquired under the Land Acquisition Act. No one can come to the court and say, but I had an order of attachment. How could the government take over my land when it was by attachment of a court?
What is the general answer? Forget the facts or
Yes, ma'am.
context. That operation of law will prevail or decree?
Operation of law.
Even generally, without any context?
Yes, without any.
What is that proposition?
No, the proposition is,
Prevail or decree of court will prevail?
my lord, a decree of court will prevail so long as, my lord, it is not contrary to any existing law.
Any judgment?
My lord, I can take out something, my lord. I can certainly find something, because in the context of the Land Acquisition Act, I'm sure, my lord, we will find those judgments. Because in exercise of eminent domain, when land is acquired, and if that land is under attachment by a court, question is, can it be acquired or not? Answer in my humble submission, my lord, it can be acquired. It can be acquired, my lord, because the land is now going into the hands of the government free of all encumbrances, and the government will receive the property free of encumbrances for it to distribute it in a manner that it considers appropriate. Therefore, an order of attachment, my lord, is really an order inter partes.
So saying that doctrine of eminent domain will apply to the court decree also?
Yes.
Or will take into fold the
Yes.
decree of the court?
Yes, yes.
Difficult. That much going to that extent is difficult.
Otherwise, my lord, property which is
Unless you show some judgment. Here case may be different, what they say, what you say, but we are
Yes.
generally examining the academic
No, no.
side of the issue.
my lord, in a case where if there's no operation of law, if it is simpliciter, someone trying to acquire land
No, now we're on the.
in a private sale.
Not law now. Now the second facet is eminent domain.
Yes, eminent
So
domain.
whether that concept will envelop the decree of the court also.
My lord, I may only say this. The claim for money will remain.
Or
Because,
engulf the decree of the court.
my lord, may I put it this way, my lord? I'll of course try and find an authority to answer.
Doesn't arise here.
It doesn't arise here.
Doesn't arise.
But to answer your lordship's question, Lord, every attachment is going to be between two parties. And those two parties who are rival claimants in a particular litigation, and in the context of a claim for money, a property is attached for the benefit of the decree holder. Now, my lord, if the land is acquired, because I cannot think of any other reason, my lord, by which land is taken over by the state, because it is taken over by the state as opposed to a private sale, where the land is taken over by the state, then, my lord, at that point in time, the decree holder may still have a claim for money, but his claim for money will stand substituted to the compensation which the government will pay, and nothing else. And therefore, his right, my lord, will remain only of money and not the right to the property. And therefore, where the property ultimately is transferred by virtue of operation of law to the government, government receives it free of encumbrance. The inter se claims for money may still continue between the parties. And therefore, my humble submission, Lord, is even in a case where there's a decree to transfer property from A to B, which is passed, or a declaration of title in favor of someone else, where the court has passed such a decree, the consequences, land will also go, but who should get the compensation may differ in the context of land acquisition. Like your lordships know, my lord, under the Land Acquisition Act, when there are rival claimants to money, to the property, that question is answered by the reference court while deciding the question as to who should be paid the compensation. In all of that, the consequences, land will go to the government free of encumbrance without any reference to attachments or right, title, or interest of any particular party. Ultimately, the government receives it free, and then who it should go to will be decided not in the context of the Inams Abolition Act by virtue of the provisions of sections 4 to 9. And in our case, not all under 9. Because it is not the case of Kemparaju that he was a tenant. He also claims, my lord, he has title to the extent of 160 acres of land. And it is on the basis of that title that he makes a claim. Now, question is, does he have title? If he does not have title, the question of making an application would not have arisen. And in his case, it's even worse because he never made an application. Though he purchased, he says in 1968, he never made an application till 31/12/1979. And therefore, in terms of section 10(1)(b) or 10(2)(b), the land, my lord, could never have, his claim stands obliterated completely. And the answer is, oh, there's some destruction of applications, therefore it is destroyed. Therefore, I don't have my application. but you knew in 2000 when you made an application that you are coming to be impleaded, saying, I also have a right. But you never said, I've made a claim, this is my application, and this is the basis of which I made a claim. None of that is there. Therefore, your right stood completely divested as of 31/12/1979. And then you not learn a single judge says, because there is an order of attachment, therefore I hold that it stands outside the act in some way, and therefore you are entitled, but you are entitled to be registered as an occupant to the extent of 160 acres of land. And that, my lord, is the ultimate finding your lordship will see at page 122.
But you both are owner or not?
We are owners.
They are.
He is not an owner because, my lord, he purchased the property at a time when the property did not belong to me also. That period, my lord, from 1959 to 1968, the owner was the government. Because this property stood vested with the government free of all encumbrances and attachments. Then if the court did a sale, it did it in ignorance of, my lord, what the position on the ground was.
So according to you, the other side stands outside the category of the
Inamdar. He stands outside the category.
and eligible to be granted the land.
He's ineligible completely for two reasons. One,
Understood.
One, there's no ownership. Secondly, there's no application.
Correct.
Both grounds. You may be the Inamdar, my lord, but you may just choose not to make an application.
I was asking therefore that if the, for sake of argument,
My lord.
their application is to be treated as having been made, and also there is your application, then amongst you two, is there any priority?
Lord, amongst the two of us, the question will be, does he have a right?
No, we said.
No, no
yes.
priority between the two of us. No priority.
How it will be decided in case of more than one application? If
Then,
more
Lord,
than one valid application,
yes,
then
more than one valid application, then it will be determined on who, my lord, there can't be more than one owner first. For a particular property, there can only be one owner.
there might be more than one tenant.
Tenants may be there.
In
Yes, each one is entitled to make only one application, it's not one application for the entire proceedings.
No. But if there are, in this case also, there are about 4 applicants for different portions of land.
Is it a situation contemplable
Yes.
that more than one application?
Yes, my lord, it is a concept, my lord, which is always there. That is the source of the dispute. If there's only one applicant, there's never a dispute. Then, my lord, either a tenant has come or the Inamdar has come. Inamdar comes and says there are no tenants. Many a times the dispute is between tenant and Inamdar because Inamdar says he is not my tenant.
Then tenant will go.
Tenant will file an application saying, no, you must grant it to me. He'll produce documents to show that he was paying rent during that relevant period. Then the tribunal will say, Inamdar, you don't get the right. Tenant will get the right.
Ultimately, the tribunal will decide.
Tribunal will decide that question.
Amongst the two identically situated or similarly situated, who is entitled?
Who is entitled?
So what are the criteria for deciding?
Criteria is not like determination of ownership itself. In the context of Inamdar, because we're not talking of tenants in this case,
Ownership.
only ownership. It will be on a determination of who's the owner of the land and to what extent at that undisputed point in time.
Correct.
Therefore, in this case, other than me, there are certain other foster sons or foster children who also make a claim for about 320 acres of land. In addition to me, I say I'm entitled to the entire 500 acres. They claim they're entitled to it. That now, my lord, has been sent back for consideration by the tribunal. In the case of Kemparaju, however, court says, because I find that there was a court attachment, therefore he stands outside of all of this. He is therefore entitled to 160 acres of land. That, my lord, is a finding made by the learned single judge. In my humble submission, that finding could never have been made because a finding of fact had been recorded, my lord, by the land tribunal that there is no application filed. And secondly, that he was not entitled to any property right. Those two are findings of fact. To upset the finding of fact, the argument is there's an order of attachment. Because of the order of attachment, I'm entitled to the property. And to make that finding, you say, therefore, Section 6 of the Act does not apply. And therefore, attachment is in some way higher than Section 3(1)(f) of the Act, which specifically provides for dissolution of an order of attachment. Then what 3(1)(f) will have, in my humble submission, no meaning at all.
Attachment is higher than 3(1)(f).
No, my lord.
No.
3(1)(f) considers attachment and dissolves it.
So date of post vesting, the group of words, date of vesting in 31F refers to which vesting?
Vesting, that is 1959.
59.
So
And there is no dispute.
no dispute. No dispute on that.
Will be subject to the provision of section 73,
73, transfer of property act.
transfer of property. Today your turn will not. We'll discontinue at 4:15. 4:15 will discontinue.
Yes, yes, of course.
So that other matters can be.
Yes, of course, but I think in this case, Mr. Vishwanath may have little to say. My learned friend will have everything to say.
Tomorrow we will continue.
Tomorrow.
ಅಲ್ಲ ಸರ್ ಇನ್ನು ಆಗಿಲ್ಲ
ಆಯ್ತು ಮಾಡಿ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
ಅಲ್ಲ ಮುಗಿಸ್ತೀನಿ ಇವಾಗ ಒಂದು 5 ನಿಮಿಷ.
I am the contesting respondent. Yes, I am the contesting respondent. Mr. Vishwanath may support me. ಅದು ಗೊತ್ತಾಯ್ತು ಅದು.
Section 73 is only with respect to mortgage property. And the right to receive, there's nothing else.
Then
Lord, one judgment, Lord, I'll write and then I'll. Lord, this is a judgment which. This is of course not in the context of the Personal and Miscellaneous in Arms Abolition Act, but Religious and Charitable in Arms Abolition Act. But the context, my lord, and the concept is the same. It is only the nature of inam which is different. This judgment, my lord, actually, in my humble submission, explains the concept of inam and its abolition, my lord. Can I request my lords to look at para 91? '92, my lord. May I take your lordships to 92, my lord, 92 onwards? Thus, on the issuance of the notification dated 4/4/1970 under subsection 4 of section 1 of the Act, section 3 of the Act came into force, as in our case. As a result of which, with effect from the date of vesting, which in respect to inam means the date appointed by a notification issued under subsection 4 of section 1 of the Act to be the date on which the provisions of the Act, including section 3, came into force in such inam, the consequences mentioned in section 3 of the Act would apply. The said date was 1/7/1970. In that case, 70, in our case, 1959. In Kumban Lakshmamma versus others, the concept of an inam has been discussed. According to the Privy Council, inam is a well-known word of Arabic origin, which means reward or favor. An inam holding may be of a field only, or a village, or a tract of several villages. Grants consisting of a whole village or more than one village are technically called major inams, to distinguish them from minor inams, which are grants of something less than a village. Further, a grant of an inam could be in the nature of an endowment of revenue rather than of land for the purpose of cultivation. As regards the expression tenants in the context of tenants of landlord in respect of land, it was held that the word tenant should be read in a stricter sense, who has been let into possession by landlord. Term does not apply to tenants in a looser sense of the word, as those in cultivation of land, the origin of whose rights is not known. Further, the expression tenant of land must mean to lands belonging to his landlord. In Muttu Subramani versus so-and-so, reference has been made to Subramanya versus Kailasa Santana, when it has been pointed out that the word Devadaya, that's specifically with respect to the Devadaya inam or religious inams, make look at 95. Para 95, not at the bottom of the page, just above para 95, whether under the provisions of the Act, filing of an application inter alia under section 6, 7, 8, 11 and 12 of the Act is necessary.
Where you are reading?
Just above 95, 95, para 95, just above that. The question,
Yes.
whether under provisions of the Act, filing of an application inter alia under section 6, 7, 8, 11, and 12 of the Act is necessary. A perusal of the scheme of the Act would indicate that with effect from the date specified in the notification issued under subsection 1(4) of the Act, which is 1/7/1970, in the instant case, certain consequences ensued, which are delineated in section 3 of the Act. Sum and substance of the consequence are as follows. All right, title, and interest vesting in the inamdar in respect to the inam land ceased and became vested absolutely in state of Karnataka, free of all encumbrances. The inamdar ceased to have any interest in the inam other than the interest expressly saved under the provisions of the Act. 3. Agricultural tenants and other tenants in the inam and persons holding under them, the holders of the minor inam were, as against the government, entitled only to such rights and privileges and subject to such conditions as provided for by or under the Act, and other rights and privileges which may have accrued to them in the inam before the date of vesting against the inamdar ceased and were determined and not enforceable against the government or such inamdar. Government, however, could not dispossess any person from any land in respect to which they considered would prima facie be entitled to be registered as an occupant or to be continued as a tenant. Thus, on the vesting of all inam lands in the state government, certain rights were reserved in the inamdars as well as tenants. It is, as per section 6, tenants could inter alia seek for continuation of tenancy under the Act. 7, a holder of minor inam could make an application. Under 8, an inamdar could make an application of registration of occupancy. Said applications have to be considered as per section 9, which deal with determination of claims for registration of occupancy as well as continuation of tenancy. In fact, subsection 2 of 9 prescribes a time frame within which such an application could be made inter alia under section 7 and 8. Section 9(2)(b) is significant, and it states, where no application is made within the period specified in clause of section 9(2), the right of any person to be registered as an occupant shall stand extinguished, and the land shall vest in the state absolutely, and such land shall be disposed of in accordance with the rules relating to grant of lands. This, of course, is subject to any right of tenant of such land who has made an application claiming any such right. Having regard to section 9(2)(b), it is held that it was incumbent on the inamdar or holder of the minor inam, as the case may be, to make an application before the land tribunal. If an application of the tenant of the inam land was also made, then the applications would have to be considered together and the respective rights determined in accordance with the Act. But when no application was made by the inamdar under the Act, then it implies that the inamdar did not seek to claim any right or privilege as per the provisions of the Act. This, in our view, the making of an application under the provisions of the Act is a sine qua non for claiming any right or privilege under the Act. This, my lord, is, in my humble submission, that is, of course, in the context of the Religious and Charitable Inams Abolition Act, because sections are different, but I can tell you, lordship, they are all mutatis mutandis. All enactments are almost identical in language except the section number. Therefore, the learned single judge's order, in my humble submission, insofar as the right of Kemparaju is concerned, was completely incorrect in holding that because there is an order of attachment, therefore the Act does not apply, and therefore, since the Act does not apply, he stands outside, is one finding. And the next finding is, because there's an order of attachment, therefore the sale is valid. And since the sale is valid, he's entitled to make an application. But there's no finding as to when he made the application. Because in my humble submission, he never made an application. And only application is made was in 2000 when he tried to come on record as a party to the proceeding, which was already going on, and not as an applicant. And therefore, respectfully, on both counts, whether as having any title or having made an application, he must necessarily fail. I'm very grateful.
Tomorrow, yes, ma'am.
Tomorrow. After, if any miscellaneous matter at 2:30, soon thereafter.
Yes.
May I just make one submission to the court, my lord? Your lordship has 2 minutes. I'll just make a submission. The one issue that your lordship raised, whether an order of a civil court would have precedence over the vesting that has taken place, my lord, that is answered in the Act itself. One thing your lordship must note, I mean, it defies logic to say that the order of the civil court will be subservient to the Act. I'm only bringing that Otherwise, when the property is attached, it is attached and court becomes custodial edges of that property. Therefore, to say that the court is divested of that land because it has gone to the government would be carrying it too far. Just have a look at section 14 for a minute. All these acts are saved. 3(1)(f) is not cast in stone. 14 is the exception to that. Just have a look at 14, my lord. Savings of rights in certain cases. Section 14. I am only bringing the legal proposition to the Lordship's notice. Where before the date of vesting, an inamdar has created any right in any land which vests in the state other than a land registered under so and so, including right in so and so, the transactions shall be deemed to be valid and all rights and obligations arising thereunder on or after the date of vesting shall be enforceable by or against the government. This is it. This is what saves it. Now coming back to the judgment that was cited by my friend, please have a look at that judgment again, my lord. Please look at para 93, 95. What is saved is there in 95. Para 95. Para 95. The middle of the sentence, my lord, of para 95, the sum and substance of the consequences are as follows. All right, title and interest vesting in inamdar shall land seized so and so. Then second, the inamdar ceased to have any right and interest in the lands other than the interests expressly saved under the provisions of the act. So expressly saved is what is saved under 14.
Attachments are not saved.
Then
What
Lord,
is saved is a right in the mine or
then
quarry.
your lordship, 1 minute.
Sorry, sir. Please.
Then one of the argument was that in 79 it is stopped. If you don't file the application within 79, the right is lost. Please look at the rules, my lord.
That's what the Karnataka High Court says.
Mysore Personal and Miscellaneous Inams Abolition Rules. Rule 7. Rule 7 of the rules, my lord. Rule 7.
Page 82.
If your lordship has the same book,
I don't know whether.
then it's page 82, my lord.
ಅಲ್ವಾ ಒಂಗ ಕೊಡಿ ಅವ್ರಿಗೆ ಪ್ರಾಬಲಿ ಇದೆ ಕೋರ್ಟ್ ಆಫೀಸರ್
7(1) says for the purpose of claims under section 10, Kadim tenant, etc.
ಕೊಡಿ ಅದಿಲ್ಲ ಅಂತ ಅದ್ರಲ್ಲಿ
Court officer.
For the purpose of the claims under section 10.
Yes, yes. Then after that, there's a proviso. Provided that applications after the expiry of the set period of 6 months shall be made to the state government if the satisfied he had sufficient cause for not making, etc. Then next, one more proviso. Provided further that the state government shall not consider any application received, then in brackets, after the expiry of 1 year from the date of commencement of the so-and-so Inams Abolition Amendment Rules 21. So right up to 2022, it has been extended, the period for filing application.
Act. Rules can't change what is there in the act.
No, both the points that
I don't know.
Anyway, I'm sure these are points that will be raised. I have nothing to say, but what was troubling my lords about whether an order of a court or a decree of a civil court will take precedence over the vesting.
I'll have to answer an argument advanced, my lord, by a counsel who's not representing this party.
I'm
answer
one of the respondents. What can I do? You made me a party.
But you have no right in
I'm
this
bound to
claim.
be heard. I'm bound to be heard.
You invited him.
We'll consider tomorrow.
Yes.
We'll start at 3:30 so that we can continue up to 4.
Please.
3, 4.
Yes.
Much obliged.
Lordships kindly, my lord, I think there's a reference tomorrow. If your lordship is taking it up at 3:30, then won't hardly get in. It's there, I have an email here. There's a circular that's issued.
There was a.
ಇಲ್ಲ, ಇದೆ ಗೊತ್ತು, he also said that.
ನಾಳೆನಾ, ಸತೀಶ್?
ಇದೆ ನಾಳೆ. ನಾಳೆ reference ಇದೆ.
We'll have it in the morning if it is.
ಅಲ್ಲ.
If it is, if your lordship could accommodate in early.
2:30
2:30 3:00 ಒಳಗಡೆ ಮುಗಿಯಲ್ಲಪ್ಪ.
ಆಗತ್ತೆ ಮುಗಿಸುವ ಅಷ್ಟ್ರಲ್ಲಿ.
We'll see how it develops.
2:30, my lord,
We'll try to take up subject to other matters.
please.
Serial number 2, the contempt matter. My lord, the accused number 2 is shown as the alleged secretary. The word alleged is used and wasn't a party in the writ petition.
Not a party, we know that.
Obliged.
We'll get it deleted at the next.
Obliged.
Seal number 14. Mana agana?
Serial number 14.
14.
Lord, appellants, my lord, are transmission and distribution companies and traders, my lord, the state sector.
My lord, appealing for responding number 1, please pass over, my lord.
Pass or will not be possible. We'll go to some, any urgency.
Lord, I had sought for a stay, my lord, but they're not, they said they are not enforcing the order for the time being on the last date.
24th of April.
Is that then? Number 16.
Notice returnable on in delay condonation, 23rd June. Right, none present, notice returnable on. And 18, same order. 18 state.
18. 18 to 20, my lord, or state appeals, my lord. There is delay.
Heard learned additional government Mr. Harish for the applicant state. Notice returnable on 24th April, 24th June.
18, 19, and 20, my lord, identical issues are involved. That has to be tagged along with the contempt petition at serial number 77, my lord.
77 in order to be listed with writ appeal number 1776 of 24. Yes, 21.
Seal number 21.
Is coming for the first time, 21.
Yes.
The respondent.
Delay of 18 days.
21 minus.
Leave to appeal.
Oh, the 21.
Prosecute the appeal.
My lord, the transfer order has been set aside
Transfer order.
by the learned single judge, my lords. On the ground that was not notified, there is a principle of natural justice violated, etc. is the ground.
Who are you?
Now, my lord, I am the person who is placed in that post, transferee post, my lords. This is the reason, my lords.
Order has
The-
already been implemented. I have already been taken charge, my lord, since from the March, February 24th. I have been working in the transferred place. And the appellant before the Sambu court is also, my lord, taken charge in the place where he was transferred. My lord, the writ appeal may not survive. Because, my lord, he has been working for the last 8 years at a single place. And I have got, my lord, 1 year of service for retirement. On my request, my lord, I have been transferred. Because, Lord, I got 1 year service and this it's near to my native place. Lord, since I've been suffering from ill health, Lord, I made a representation. So by considering my eligibility, Lord, I've been transferred to Lord the Kanakpura depot. Lord, now subsequent, there are 2 orders, Lord, 2 writ petitions filed before the learner single judge. And both of them have been allowed. They have been sufficiently heard, my lord. There is no, my lord.
You were there as respondent 4.
Pardon me, my lord.
You were there as
Yes.
respondent 4.
I was working there, my lords.
Why there is a leave to appeal?
Pardon me.
You were a party in the main proceedings.
There are 2 proceedings, my lords.
So why you have filed leave to appeal?
In one case, I was not a party, my lord. They filed an application to consider where I was not a party, my lords. In the other case, I was a party, my lords. So in
both it is there.
No.
First, my lords, it's to consider the representation.
Why 2 appeals?
Lord, in the
We were not
first
made
writ
parties in
petition,
first case.
direction was sought to the respondent authority, my lord, for giving effect to the transfer order. The appellant before was not a party in that writ petition. When the writ petition was pending, my lord, the order was modified, my lord, that was challenged in the second writ petition. And the appellant herein was also made as a party. He was sufficiently heard. Matter was considered at length.
In the second
And
matter,
then-
yes, my lords, was heard. So since I'm challenging both the orders, my lords, I pray the honorable court to kindly grant me permission to challenge the other order where I was not a party. In one of the writ petitions, I was not a party. In the other, I was, but common order has been passed, my lords. Only on that count, my lords. And I'm the person who is affected. Now I'm removed on account of this order, my lords, of the learned single judge, my lords. I'm the affected party.
Today, my lord,
And
I have
also-
received the appeal papers. My lord, I will, my lord, file wakalat and make my submission, my lord, on the next day. And just today, my lord, I received the appeal paper. Lord, in one writ petition,
My
I have
lord,
to
sir,
file the wakalat.
The delay
And then
also,
may I
yes,
make my
23 days delay, my lord, 18 days delay, my lords. I pray, your lords may kindly, my lords.
So I 1 of 25. In the writ appeal number 81 of 25. This is 21.1. The present application is for condonation of delay of 18 days. Full stop. Having heard learned counsel for the respective parties and considering the averments in the accompanying affidavit, explaining the passage of time leading to delay, which makes out sufficient cause, delay is condoned, application is allowed. We are saying all are appearing.
Now appear, but our friend has a wakalat in both
Here
cases.
for the respondent 2 to 4, my
I
lord.
am the
Appeared.
contesting respondent, my lord. I am the contesting
Then
respondent.
notice will have to go in all both matters. Notice returnable.
Appeared,
In
my lords.
connected matter,
Purpose
I'm
appeared,
here
my
for
lord.
respondent number 2 to 4, my lord.
You are there, madam.
Yes, my lord. In the writ appeal 81 of 25. Or
So-
21.1.
Here select a hard learned advocate which is on so the applicant. Learned advocate Mr. For number 1
I am for the respondent.
and learned advocate Miss Anuja
Rakshita DJ, my lord.
Rakshita
DJ.
DJ appearing through video conferencing for number 2 to 4
2 to 4, my lord.
2 to
Respondent.
4 and same order.
And IA for permission to prosecute in another case, my lord. That also, your lords, please,
That also both are granted.
please, my lords. May humbly submit, my lords. Sorry, only reason for setting is that the transfer order is this. He has not been heard
We are
except,
granting in both appeals the relay condonation and leave to appeal is also granted.
please, my
Appeal
lords.
will be posted whenever
And
you.
operation of the impugned order,
No, no.
kindly,
It can.
otherwise,
Appeal will be posted when?
at the earliest available.
22nd of April.
Be most good. Please. Please.
Number 22.
Appearing for the appellants, IA 2025 file seeking permission to file this writ appeal. Since my father was the petitioner, he died, and appellant's father is died before during pendency of the writ petition. It was not brought to the notice of the writ court, and the judgment is passed against dead person.
This is also leave to appeal,
Yes,
leave to appeal.
yes, that's why we filed application to IA
Oh.
number 2, seeking leave of the court,
Who are you?
We are the legal heirs of deceased petitioner, The appellants before this honorable court are the legal heirs of
Been
deceased
granted.
petitioner.
Please, my lord. Leave
Leave
to
to appeal is granted. IA number, not one.
2 of 20,
Two of, no. 2 of 25.
25. And for list admission,
You are claiming some compensation.
Yes, yes, we are for challenging the acquisition proceedings slum. Alternative relief also sought to pay the compensation. as
Appeal will
per
be
the new
listed,
act.
appeal to be listed on 25th of April.
Great.
Number 23. Vijay Kumar.
The appellant was on deputation from Director Municipal.
Left 9 days.
Not this. Sought for stay of the impugned order, my lord, for the
Plus
reason.
delay is condoned, appeal cannot be adverted. So everybody appears, then we'll condone, otherwise notice will go.
Now, I take notice for respondent number 1, my lord. Respondent number 2 to 5 is BBMP. Notice has to go.
Notice returnable on 9th of June.
Short date. Short date, my lord, it's a matter relates to repatriation. I've sought for an interim order. My lord, repatriation is but done by an incompetent authority. That's the reason, my lord, the tribunal, the single judge, my lord, has not noticed that it is, the third respondent commissioner is not competent to repatriate my services, my lord. And my absorption in the company is, proposal is pending consideration before the first respondent. My lord, and, my lord, a proposal was sent to place me under suspension, my lord, that proposal has been stayed by this honorable court, my lord. The last single judge stayed it.
17th. 17th April.
Please, my lord.
17th April.
Please.
List number 2 for pronouncement of judgment in writ appeal 299 of 2025.
So this is IA for stay of the judgment in on a single judge. In the appeal, number writ appeal 299 of 25. We have considered almost all the arguments of both the sides, noted them. And we have observed that all these arguments for staying of the judgment and order were relatable to the merits of the appeal. So the prayer for stay as such is not accepted. However, we have found the favor in the submission that this judgment, which is essentially not a judgment in rem, cannot stall the investigation in respect of other accused and other persons involved in this case. So therefore, we have permitted the investigation to continue. With these observations, inter alia, as the court has permitted The inquiry and investigation to be continued against the other accused as well as other persons. As may be required, the applicant enforcement directorate, the investigating agency shall be at liberty to utilize all the documents and materials which may have been gathered, recovered and secured in course of the search and seizure at the place of the petitioner, as well as to utilize the statement recorded for the purpose of rest of the investigation in accordance with law. This would not prejudice the respondent petitioner as his case is pending consideration on merits. Whether the petitioner statement recorded under section 17(1)(f) of the Prevention of Money Laundering Act to 2002 can be ordered to be retracted by the court is also an issue at large to be considered in the appeal. All the investigations under the Act are permitted to be carried on in accordance with law, notwithstanding the judgment and operative order of law on a single judge impugned in the appeal. The applicant investigating agency therefore is entitled to proceed to carry on the investigation in respect of other persons or the accused in accordance with law. With these observations, clarification and providence, as well as the directions, the present application is disposed of. Correct. Extremely grateful. So we'll get the copy uploaded after half an hour or so.
I'm grateful.
After once I check it.
I'm grateful. Would your lordship fix a date for the hearing?
Pardon?
Would your lordship fix a date for the hearing, my lord, of the main?
It is
matter?
already there.
No, for the main matter.
It is already there. It is already there. That also we have noted. That granting stay of the appeal, which is to be posted immediately for hearing, as well as it will amount to granting of the main appeal. Therefore, no total stay, but these clarification.
No, Lord, I was, is there any date fixed for hearing this writ appeal?
Yes, appeal,
8th April.
appeal, 8th,
Correct.
already on that.
Yes, now I recollect. Yes, 8th April. I'm sorry. I'm grateful.
Deeply obliged.
Commercial appeals, still number 24.
My lords, I am for the appellate. I am for the appellant in this matter, my lords. A divergent finding. I am a claimant, appellate. Award was in my favor. It was reversed by in the commercial appeal, by lords, by the commercial court. The findings recorded is entirely contrary to the case on hand, my lords. Your lordship may find award at page 147. Admittedly, it's a matter pertaining to termination of the lease. I am a lessee. Admittedly, 15 crores was the security deposit, and they have to refund us 5 crores odd.
We'll issue notice.
Yes, my lord. Yes, my lord.
Application is allowed notice returnable after vacation.
Yes, my lord.
23rd of June.
Much obliged, my lord.
Number 25.
Appellant, my
So
lord.
Lokesha.
Lord, judgment passed by the commercial court, my lord, wherein though I have proved that the amount paid is non-refundable, without considering the exhibit D1, which was confronted and relied upon.
So who are you? Defendant?
Yes, my lord.
Notice.
Stay is required, my lord.
Then deposit the amount, entire amount.
No, my lord, I am not liable to pay the amount itself.
That is the matter of determination in the appeal. It is a money decree. If you want to stay, you have to deposit.
No, it is not a money decree, my lord.
It is money
It
decree.
is
What
based
else?
on a joint development agreement, my lord.
What else it is?
My lord?
What else it is? It is money decree, whatever may the facts. If you want to stay, then deposit on condition.
Then notice may go on.
Notice returnable on 24th of June.
Number 26.
26, I appear for the appellant's counsel.
But appear for the respondent.
Lord, matter arises out of a section 9 petition filed by the respondent. Parties are, my lord, family members and companies incorporated by family members. This petition that they filed before the commercial court relates to trademark. My lord, according to them, they own a trademark. The fact of the matter is that I have prior user since 1989. Their prior user, I'm sorry, 1984, their prior user is about 1993 at the earliest. So I have prior user. Now, my lord, there were some documents apparently executed, which we dispute, called settlement agreement as well as, my lord, an assignment agreement. On the basis of those documents, they institute the Section 9 proceedings. I must tell your lordships that they filed the Section 9 proceedings almost about 8 or 9 months, my lord, the course of 2024. No ex parte order was granted. In December 2024, we instituted a suit, a commercial suit, asking for a declaration that the assignment agreement is not valid and it's not binding on us, as well as, my lord, for certain injunctions. The commercial court grants us an ex parte ad interim injunction in our favor. Now, when this was sought to be brought to the notice of, my lord, the learned commercial judge hearing the Section 9 petition, the learned judge would not take that on record, but instead passes the impugned order. My lord, the impugned order proceeds on essentially on 2-3 points.
Now, which is the main case? It says till the disposal.
Lord, yes, that is my submission. The learned judge has passed orders on injunction while keeping the main Section 9 petition alive.
How can it?
That is really quite a bizarre position.
Dispose of by directing learners.
Lord, yes, but my submission is that this order may have to go.
Lord. In the meantime, if I
But
may
I'll
submit,
just-
Lord.
I'll just
In the
point out.
meantime, the Section 9 petition, Lord, court has heard finally, this is an interim measure. Court has heard it finally, and now it has to pass orders.
Lord, it doesn't work like
It
that.
is kept for their reply on 3-4.
It is kept for orders.
No,
It
it
is
is
kept
not
for
kept for
their
order. It is
reply.
kept for arguments.
Reply. Final arguments are complete, Lord, on the main.
It's kept for
It's
arguments.
kept for reply on 3-4. That is
It is
tomorrow.
kept for arguments. Lord, may I complete? My
If they
submission
complete
is
their
that.
reply, Lord, matter will be reserved.
When it is heard substantially.
Yes.
If not fully,
Yes.
then let it be.
I
disposed.
quite bow down to that, but the difficulty is,
Tomorrow,
just
Lord.
1 minute, please. Just 1 minute, please. Lord, the difficulty is this. Today, there is an order that is staring me in the face. This, in a Section 9 petition, there is really no difference between an injunction being granted on an interlocutory application and the main matter. So unless, and this is a very detailed order passed, so unless this order is varied, set aside, or in some way, my lord, kept aside, the learned judge would proceed on that basis. This is a difficulty that is a practical difficulty that I have to point.
Arbitrator is appointed.
No, arbitrator is not yet appointed. They have initiated arbitration. Yes, notice is given. Now, my lord, I have another submission to make here. These are family members. Really, this is a matter that is fit for resolution because ultimately, if your lordships are kind enough to
What
take
is
the.
trademark.
Yes, because what has happened is,
Trademark for what? What?
my lord, both of us are in the electrical component manufacture business. It is really a case where I started the business. He is my brother-in-law. Of course, and there are a lot of physical handicap. I'm not getting into those aspects of it. All I'm saying is, for a long period of time, the arrangement was that I would procure orders, he would manufacture only for me, and I would then market it. Because of that, the trademark that was being used was common. Now, my lord, there is some divergence. And ultimately, if we can find some common ground, it would put a quietus not only to my suit as well as these proceedings, instead of having to go into arbitration. And after all, these are family members. Now, in this background, may I make, now that my learned friend is appearing, in fact, I must also tell your lordships, they filed an application before the learned principal judge for transfer of proceedings both to one court. That was rejected. All of this, my lord, is just multiplying proceedings. Instead of this, if my learned friend is now appearing, can we just, my lord, have the matter referred to mediation for a short date? We'll just try and have the prevail on the parties to resolve it.
One issue here is, Lord, there is a settlement deed which settles all the disputes between us a few years ago. And in the settlement deed, the trademark is assigned to me. Today, they have instituted a suit seeking setting aside of that settlement deed. Though there is an arbitration clause, that's a different issue. Lord.
Vivek Reddy, there is no point in hearing the matter if it is substantially heard by the court.
Yes, Lord. Ultimately, the lordships are right, Lord. The learned trial judge, the Section 9 court must decide.
Without going into merits, let it be decided.
Right. In which case, would your lordships kindly say that essentially that he hear it afresh without being influenced by this order? Otherwise, what happens is that he will say he's bound by this order.
Already heard and it is kept for.
My lord, no. Let me just take a minute and explain. My lord, what happened was Section 9 petition is filed by them, my lord, in May or so of 2024. Along with that, they file an application for grant of interim relief. by way of filing an interlocutory application. After the passage
At the
of
best,
9 months,
we can at the best say that
Yes.
this order is interim nature and will operate accordingly while deciding the say main proceedings.
Main
of
matter.
bill.
yes, but the insofar as the main
And the
matter
matter is
arguments
there
are yet to be
tomorrow.
heard. My learned friend, just bear with me for a minute. Insofar as the main matter, we are yet to be heard. In the main matter, we have not been heard. That has happened is, and these arguments were heard, my lord, before the vacation. And the order was passed in January. So therefore, there is some break in what has transpired. That's what I'm trying to tell.
Is the ex parte order?
No, it is not an ex parte order. I was heard. But the difficulty is he's passed a fairly detailed order. He's bound to follow his own order.
Come
But
tomorrow.
this
morning at
matter,
But can I just make a request? Your Lordship, may keep it day after tomorrow. My lord. Proceedings and trial court be deferred.
no,
for
my
a-
lord, that's not necessary because even otherwise,
Only
it is
for
the court that is.
Yes,
only for dictation purpose tomorrow.
tomorrow. Great. Tomorrow or day after. Anyway,
Right now, there might be reflection on my.
please.
So it is 5 o'clock. So we'll just one thing. We are disclosing our mind. I will incline to dispose of that line.
Yes, the only request I would,
Of the time limit for the court.
I have no difficulty with any of that. All I would request is that the learned trial judge, the commercial judge, hear the main section 9 without being influenced by this order. Otherwise, my lord, there's nothing that remains for me to argue.
This is interim.
So this is on an interim order.
That's all. As long as that is made clear, there's nothing more that I. Great.
Please. Public.
Anything?
Serial number 40.
Serial number?
42.
What?
My lord, it is only for
Your Lordship,
Quashing of
you
the-
have it on 15th of April.
No, my lord, I
Yes.
need some time, my lord. I have to work on it.
I have a very little time.
No, my lord, not little time. My lord may see the prayer.
been
No, this
granted
kind of pressure
sufficient
cannot
time.
be brought about, my lord. My lord may see the prayer. If I am, my lord, if I am unreasonable, my lord can.
Also, we were inclined to keep it in 24.
Very
Keep it in
well.
24.
Very well.
24. Can I?
Please, Lord, because
1 week they have at least.
on that day, they positively, they have to come up with.
My
some
lord, this
response,
kind
Lord,
of
because
pressure, even
cannot
I have
start
to use my mind,
are
my lord.
delaying the
Applicate,
matter.
I have to apply my mind.
Take my rights.
No, it can't be concluded like that.
My lord may see the prayer, my lord, quashing of penalty proceedings and refund.
Because day before yesterday, they have stopped 3 vehicles, recovered penalty. Every now and then, they should come up with a fact that as to why they are stopping the vehicle.
My lord, he
Despite
cannot
we
take
are
on a
having all
roving
the-
inquiry, my lord. He has to file a
Submission.
petition before my lord and seek appropriate orders.
Submission she is making, Lord. This is not the way.
No, this is not fair, my lord. He has to file petitions with regard to that cause of action.
Lord, we are having all the documents. Despite that, Lord, for extraneous consideration, he is stopping the vehicle
So
and
all-
recovering the penalty.
All those things will examine on 24.
Obliged, my lord.
Can I?
That may kindly consider on 15th, Lord, because
No, my
They
lord.
will not be able to take instruction.
only till June we have permission. After that.
My lord, we have 1 week, my lord, and because of which my hands are tied from 10 till the 14th. I have no stenos, my lord.
We don't have steno every day.
I have not used
Into
the
the
steno at
volume
all.
of work. Not that we don't have steno.
No, my lord. My difficulty is that, my lord. Otherwise, I wouldn't be this thing with my lord. I wouldn't be squibbling with my lord for this time.
24.
Obliged.
Can I make a request, my lord?
With my lord.
Serial number 30, this, your lordship had posted it today. It's a commercial appeal, my lord, where we had an injunction with respect to a trademark. And the suit is dismissed on the ground that you did not take permission under the Bombay Public Trusts Act. There's some urgency in this, because of which the injunction is vacated now.
0, 30.
30th, yeah, 30.
When shall?
Sorry?
When shall we?
Tomorrow or day after, my lord.
No. 22nd.
The injunction is gone now. my lord. Problem is that we had an injunction all through.
Then 15.
15, right.
My lord, serial number
48 and
40.
29.
19 and 20. Please appeal, my lord.
I appear for the complainant in the contempt petition, which are also listed today. It appears, my lords, in those matters, notice have been issued on IM. I may be permitted to take notice on that, so that on next case we can proceed with it. 18, 19, and 20. State appeal against the learner single judge government. This is a deemed regularization matter.
Who has taken? You notice. Right. Not, who, learned advocate, Mr.
Shut up,
18,
Mr.
18, 19, and
20 minutes.
learned advocate, so accepts notice on behalf of
All the private contesting.
All the-
respondents.
delay application,
Private respondents.
delay application.
On delay minutes.
It can be granted then,
Lords, very well.
so it is granted.
Serial
Serial
number
number
28 and 29.
40.
Serial number 69.
In appeal, appeal will be listed on 17,
17th of, yours on 20th.
21st,
My lord,
22nd.
22nd.
But serial number 69. But serial number 69.
Along with that contempt petition.
Lord,
Contempt petition may be connected along with that.
All are together.
My lord, 44. my lord.
Serial number 69, my lord, pertaining to, my lord, entry in the mutation register. Not state had preferred SLP, my lord, which is dismissed. They are, my lord, bound to comply the order. Not despite that, my lord, order has not been complied. SLP is dismissed, my lord, on 21/3/2025. Not direction is of the year 2012. Till date, my lord, they have not complied.
Who appeals?
34. ಬೆಳಗ್ಗೆ 10:30.
But I had approached, my lord, this honorable court. RSA is dismissed, my lord, on 19/6/2022.
25th of April.
But may I request, my lord, next week, my lord, right from, my lord, 2002, my lord, for entry, my lord, I am before one or the other court. May I request, my lord, 7th or 8th, there is some urgency, my lord. The complaint number 1 is quite aged, my lord. Next week, my lord, at least. 15th or 16th, my lord. She is really unwell, my lord. Complaint number 1.
My lord, serial number
One
107, my lord.
date.
24th, 25th or 25th.
Serial number 107, my lords. 107. A single judge has passed an order for demolition, my lords. Contrary to that, BDA has also issued a notice for demolition, my lords.
Demolition.
Yes, my lords.
Demolition of what?
Of a temporary structure, my lords, in the apartment. They have issued notice on 21st of March, my lords, and
1st of March. No?
yes, my lords.
Giving how much time? 2 weeks time.
Yes, my lords, 15 days. So it will expire on Friday, my lords. It may be taken tomorrow at 2:30, my lords.
9th.
My lords, it will be, I will be put into great hardship, my lords. So it may be taken tomorrow itself.
You said 15 days time is given.
No, my lords, on 21st, from 21st, it's been 15 days, my lords.
You
So
said 31st March,
21st, sorry, 21st of March itself, my lords.
21st of March.
Yes, my lords.
8th.
My lords, please, my lords, on 3rd, tomorrow, my lords, because on 4th, they will demolish the structure, my lords.
Then 4th.
Serial
The
number
31st matter, my lords, may I request that it be had either tomorrow or day after? It's a very short question on jurisdiction of the court.
Which one?
31st matter.
31st.
In fact, on the previous occasion, my lords were hearing, but the online hearing could not go through.
May not be possible.
Around-
23rd of February.
On 23rd, my lords. I'm
But
okay.
serial number 49, my lords. This relates to construction that is interfering with my peaceful possession of the property. Lordships had heard this matter.
My lords, I appear for the respondent in this matter.
There's some urgency, my lords. I'm
My lords.
unable to carry on my business because of the
My
construction.
lords,
that
on
is
Monday, there's a, on main hearing, the Monday it's listed before the trial court, my lords. The matter.
My lords, this is the matter where.
On 7th, my lords. It may be heard after 7th, my lords.
This is the matter, if your lordships will recall, but the court has already held that the matter is not arbitrable. So therefore, this is that. My employees are unable to.
Mr. No time, otherwise. 4th. 4th.
Fourth of it. Please.
My lords, Monday. My lords,
You are saying that Monday is the matter is kept there.
yes, my lords. It's for hearing on main matter, my lords.
For 4th it is kept.
Please.
My lord, 44, my lord.
for the.
My lords, appearing for the appellant and 44, my lords.
The challenging the surfacing proceedings, my lord. The surfacing proceedings have been kept at hold since almost 10 years now. There is some urgency. The matter may be taken up anytime next week, my lord.
After vacation.
But serial number 20.
22nd or 23rd of April, my lord. The arguing council will be for your lordship. There is an interim order operating as against the bank, my lord. The
3rd June.
But serial number 28 and 29. my lord. Serial number 28 and 29, my lord. A suit for ejectment, my lord. A execution has been filed before the court. If I am ejected, my lord, the appeal itself will become suit for ejectment, my lord. An execution has been filed before the court of company court, my lord. And if I am ejected, my lord, the appeal itself would become infectious tomorrow or day after tomorrow.
Is there an interim order?
There is no interim order. I'm sought for interim order.
Appeal is against interim order.
I have sought for interim order.
Appeal is against interim order.
No, my lord. Final order.
Then how they become infructuous?
No, my lord. If I'm ejected from the property, my lord, and a suit for ejectment has been filed.
That
And
you know how not to
an
be-
execution has been filed before the company.
Better know how not to be permitted. to be-
Certainly, my lord. But my lord, in the company court, my lord, once the notice is issued, my lord, certainly they will.
28
Well,
of April,
My lord, serial number 44, my lord.
44.
My lords, appearing for the appellant in this matter, my lords, may I request either 15th or 16th of this month, my lords? And if that is not possible, may I request between 21st or
16th, my
23rd? my-
16th, my lord.
6. What is the urgency?
Urgency is, my lord, we have had a benefit of the single judge order, notification of the year 2009. Once already the notification has been squashed
Regarding?
regarding
But
land acquisition matter, my lord. My lord, the only question is, we have not been able to enjoy the property as lordship, you are directed as last time, you just go in for the construction. But
17.
maybe
My lords,
16th,
there's a
I
difficulty
got
on
personal
17th, my
inconvenience on
lords.
17th. 16th would
On
be
16th, my lords.
pay your lordship 16th, my lord.
16.
16th.
Oh,
Deep
much
pleasure.
obliged, my lords.
My lord, serial number 98. Pray for an early date may be fixed for hearing.
Date will be given, all date will be given.
My lord, serial number 118.
Serial number 81, my lord, is a public interest litigation wherein, my lord, the ex-MLA started putting up a construction, completed the construction on the tank bund, my lord. And in spite of violation of the order, violation of the sanction plan, my lord, construction has been made on the tank bund. It is the village's writ petition, my lord, urgency, my lord. 81, my lord. Readings are completed. In fact, the respondents have filed objection.
22nd of.
Wait, man.
My lord, serial number 118.
Necessary steps will be taken within 1 week. To serve the respondents who is on some. 94, 95, 97. 3 weeks time is granted to remove the office of business, failing which. In 98 to 100, 2 weeks time is granted. Then, so. 101, 207, what is there? Okay. Regarding. Office objections, 101 to 107, office objections in each of the above cases are dispensed for the time being, subject to be examined at the time of listing of the matter. If rider is above, the registry may list the appeal or whatever petition. Give the dates, any date,
My lord,
maybe after vacation.
all after. 62 to 68, my lord. 62, serial number 62 to 68, my lord. There is no, there is urgency, my lord. I'm not reaching in last 2-3 vacations, my lord. Not reaching the matter, my lord. Not reaching the matter, my lord.
Not reaching. It's a great urgency. Greatest urgency is a matter not reaching.
We are not able
What is the real urgency?
There is contempt petition, my lord.
Contempt petition. 29th of February, 29th of April. 29th April.
Obliged.